Certainly. This trial is in the matter of case number CF5080-2018 before Justice Sir Jeremy Cook. The claimant is represented by Amal Advocates and Legal Consultants, and the lead counsel is Mr. Amr Bajmal. And the defendant is represented by Afridi and Angel, and the lead counsel is Mr. Michael Passage Joyce, and he is assisted by Mr. Sulakshana Sinyanki. Thank you very much.
Thank you. Very good. Yes, Mr. Bajmal, I've read the papers, so you can take it I'm familiar with the documents in essence.
Thank you. Good morning to you, Your Honor, and good afternoon to those in Dubai. We just a couple of housekeeping matters before I start. We do have an agreed timetable for the day between the parties. I just wanted to check if Your Honor had the chance to see that timetable.
Yeah, it's fine by me if that's what the parties would like.
Thank you. And just one more housekeeping matter. I noticed that there was a typological error in paragraph 59 of my skeleton. There's a reference there to an amount of 20 million. It should be 10 million. So I just wanted to point that out for the record.
Yes.
Thank you. Your Honor,
whilst we're on housekeeping, I think in fact in the bundle, if one looks at page 4746 and 4747, there are in fact only 2 pages of my skeleton argument included in the bundle, but I checked and have confirmed that you've received it separately. So it's simply a noting exercise that it isn't in its entirety in the bundle.
Yes, very good. There's also a missing page 10 of one document or another, the points of claim, I think it is. But never mind. It's in essence the same as elsewhere as the witness statement. So that's fine. Yes, Mr. Bajmal.
Thank you. Thank you. Your Honor, you would already be familiar with the facts of the case from the pleading, so I'm not going to go through the facts again. I'm going to jump in straight to the arguments made in my skeleton. The skeleton is
Can't hear you. Have you muted yourself by mistake? I can't hear you. No. Mr. Patrick Joyce, can you say something?
Mr. Bajmal, we're having difficulty hearing you. I think the connection is otherwise.
I think, yeah, I have both of you back now, but Your Honor, your screen is frozen.
Right. It looks all right from this end.
Yes. Can you hear us now, Mr. Bajmal? It's Michael Patrick Joyce speaking.
Are you hearing anything at all, Mr. Bajmal? No. It must be a problem of the connection at your end, I think.
Mr. Bajmal, maybe if you log off and I think he's done that.
Apologies, Your Honor. I tried to log out and log in again.
Yes, we can hear you, but I can't see you.
Okay. So can you hear me, Mr. Joyce?
Yeah, you're now muted, Mr. Joyce. Mr. Patrick Joyce, you're muted.
Sorry, yes, I am, and I can.
Okay,
hear.
well, we can hear everybody. We can't actually see you, Mr. Bajmal, which is a great pity.
How about
where are you dialing in from?
From my office in Dubai. So.
Oh right, so it shouldn't be a problem.
Yeah, so everything is stable. My internet is at full.
Okay.
I don't know why is this problem coming. But
Well,
if
you're
you can
back
hear me
again
now. Okay, very good. Okay, thank you. So I was just taking you on through the order of my submissions for the day, and I am going to first address the issues which relate to the adequacy of the defense that was filed by the defendant, and then I'm going to take your honor through my submissions on deceit, and thereafter on the inducement, and then at the end I'm going to address points that arose from Mr. Joyce's skeleton. So starting with the sufficiency of the defense, the main reliance under this heading is on RDC rules 17.26 all the way to 17.28. And these rules concern the manner in which a defendant should write or submit his or her defense. So Rule 17.26 requires that the defendant must state which of the allegations of the particulars of claim he denies, which allegations he's unable to admit or deny, but which he requires the claimant to prove, and which allegations he admits. And then we move on to RDC 17.27, which states that where a defendant denies an allegation, he must state his reasons for doing so, and if he intends to put forward a different version of events from that given by the claimant, he must state his own version. Lastly, RDC 17.28 provides that a defendant who fails to deal with an allegation but has set out in his defense the nature of his case in relation to the issue to which that allegation is relevant shall be taken to require that allegation to be proven. I would like to take your honor now to the defense that was filed by the defendant, which is at tab 5.4 of the bundle, and I would be taking your honor to page 1535 of the bundle.
Yes.
If we look at paragraph 8, here the defendant is referring to paragraph 3.
I'm so sorry, Mr. Bajmal. Page again, I seem to have got the wrong page.
Yeah, so we're looking at the numberings in black at the bottom right, so 1535.
Right.
Your Honour, there is a difference between the electronic numbering and the bottom right-hand numbering. For the electronic searches, you need to add 6 to the number that Mr. Badjamal has just given. So I think that 1535 would in fact electronically be 1541.
Yeah, that looks like it. Thank you very much. So it's a 6-page difference. Thank you. Just bear with me a moment, Mr. Ajmal, while I just get my copy of the rules out. Mr. Bajmal, I have to tell you, I'm not terribly interested in the pleading points because I find your particulars of claim particularly difficult. And the question really I need to know is how you put your case in the light of the way the particulars of claim are framed, because I can see why Mr. Patrick Joyce or whoever pleaded by way of defence was struggling to know quite what to say in response. Don't let me stop you going through these rules, but as I say, I really want to know really what your case is.
Perhaps then I would go straight to the second section of the skeleton. I would like to give Your Honor just a quick brief of the submissions I make on this, and then I'll quickly move to the next section.
Yes, sure.
The summary of the position here, Your Honor, is that the defense confuses between two different legal concepts. This is the concept of denial, and then the concept of non-admission, which requires the claimant to establish each element of the claim. And in this regard, I've provided Your Honor with three main authorities. These are the Al-Hassani, the SPI North, and the Patel. And the gist of these authorities is that a defendant is expected, when a defendant denies an allegation or a matter of fact, he must provide proper reasons as to why this denial is made. The point I was trying to make with regards to the defense is that the defense fails to provide any reason as to why these paragraphs of the particulars of claim are denied. The second condition because if we look at paragraph 8 of the defense, we see that the defendant states that he both denies and requires the claimant to prove the element. So there's a reliance on both concepts. And we say that the reliance in both cases is not compliant with the rules because A, no reasons were given for the denial, and B, because the non-admittance is only applicable in situations where the defendant is not able to confirm nor deny a fact. So we say that the defense is deficient in that manner, and therefore we ask the court to either strike out those parts of the defense or to disregard them, or in any event that negative inferences should be drawn from the manner in which the defense was presented. The second point which we would like Your Honor to consider is also to draw negative inferences from the fact that the defendant refused to submit a witness statement in response. We note here that the defendant was available in other phases of this litigation to provide a witness statement during the application to set aside the default judgment. We also note that he's provided a declaration during the disclosure application. So it is obvious that he is available and he is in contact with his legal team, and therefore we ask the court to draw adverse or negative inferences from the fact that he has refused to come forward to provide his own version of the events to this court.
So supposing I'm entirely with you on all of that, Mr. Bajmal, the real problem, as I see it, is this, and I'd like you to deal with this in your own time, but it's the key point so far as I'm concerned, which is how you establish the facts upon which you need to rely to have a cause of action against the defendant personally. The general background, in the sense of what the disciplinary proceedings have shown and all the rest of it, I'm familiar with, or sufficiently familiar with, to know that other people have concluded that terrible shenanigans went on at Abraj Holdings, AMIL, Abraj Capital, whichever one it is you want to talk about, the group as a whole. But when it comes to the facts that you need for your case, so far as this claimant is concerned, you don't really get any assistance out of any of that material, even if it is admissible, because it doesn't directly go to your facts. It goes to the generality. And putting it absolutely bluntly, I'm entitled to look at the emails that are directly relevant to your case, and you've relied on essentially 4 documents, as I understand it. But beyond that, there's not very much to get to grips with, is there?
I disagree, Your Honor, because I agree with you that the claim stands without that the DFSA decisions are not the main source of information. However, perhaps if I may proceed with the submissions, I'll go directly to the questions of deceit, and then I'll take Your Honor through.
Don't let me take you out of your course, but you need to know the way I'm thinking so you can direct your submissions to it in due course.
Yeah, I'm very grateful. Yes. So I'll jump straight into the deceit. So the first cause of action against the claimant is based on Article 31 of the DIFC Law of Obligations. The DIFC Law of Obligations establishes the definition. They said this is a test that the claimant must satisfy in order for liability to arise under deceit. And the test is made of 4 limbs. That the claimant must prove that the defendant made a false statement, that makes a statement that is fraudulent, and that the defendant intended that the person should rely on the fraudulent statement, and the claimant does rely on the statement, and then the claimant suffers a loss as a result of the reliance on this statement. And subsection 2 of Article 31 states that a statement is fraudulent if its maker A knows that it's false, B has no belief in its truth, or is reckless as to whether it is true or false. And finally, subsection 3 stipulates that it is no defense to an action under this article that the claimant could have discovered the deceit. I'm going to take the test one by one. So we first need to identify what was the fraudulent statement. And there were 2 tranches to the investment that was made by the claimant. So there was a first tranche paid in around November 2015 of 10 million dirhams. And then there was a second tranche paid around May 2017. So we say that there were 2 separate statements that gave rise to each payment. So the first fraudulent statement, we say, was included in what we call the invitation letter, which is a letter dated the 29th of October 2015. If I may ask Your Honor to go to volume 5.29 at page 2466, please.
Sorry, give me the reference again.
Volume 5.29, page 2466.
529. I'm not with you at all.
If perhaps if you try to add 6 as suggested.
Well, I printed off the relevant documents. I'm going to find it in my hard copy because I can't pick it up on the reference you're giving me. Okay, so it's the 29th of October.
Yes. Yeah. Do you have that, Your Honor?
I have it in hard copy, yes.
Yes. So this is the letter which we call the invitation letter that was sent to the claimant. So it's addressed to Mohammed Al-Girgawi, Muzoon Holdings LLC, and then it reads, and it's signed by the defendant, Mr. Naqvi, and then it reads, further to our discussion yesterday, please arrange to remit an amount of 10 million to the following account, and then the account of AIML is provided. And then at the end, we see, as agreed, this amount will be invested by Abraj on your behalf under a discretionary investment mandate. So in order for us to understand the truthfulness of this document or this statement, we have to look at what does discretionary investment mandate means
Yes.
in the context of what Abraj was carrying out as a business. And in order to understand what Abraj did as a business, I would like to show Your Honor a document that was disclosed by the defendant, which is the organizational structure of the Abraj group. This is at 531, and it's the only page there, I believe. Sorry, it's 541.
Page 3,800.
So I'm very sorry, Mr. Bajmal. I'm using the case lines thing, and I need to put a page number in at the top on my find page. And so, what page am I putting in?
I will find that out. Just 1 second, Your Honor. So, Your Honor is looking at the top at 5.41. It's a document.
5.41. Right. Let's try
Yes.
that.
On the left hand side on the tabs, if you press that tab, then it should come directly, because it's the only document in this tab.
Well, I've got on the left hand side 3 hearing bundles. 1 draft parties agreed index of bundle. And then A, application of claim, B, default judgment, and so on. Am I looking at something different from what you've got?
I'm looking at the case line, and the case line is echo. And
Your Honor, may I provide a page reference?
Yes, we're getting a feedback.
Yes, we are. Your Honor, may I provide a page reference to the electronic bundle? I think it's 3806.
Right. And how have you discerned that from what Mr. Bajmal has been saying?
Because I have an index to the bundles, and that has tab 5.41 as having bundled page number 3800, but those are to the internal bottom right hand numbers,
Okay.
and to which I've then added 6, and I've just cross-referred. So I think
Okay,
3806 will get you there.
I've got the corporate structure. What I don't understand is why we've got this difference in numbering. The whole point of this case management system was that we should have be able to get the same numbers and the same documents. Anyway, Mr. Bajmal, I've got the corporate structure.
Thank you. I understood now why we have different numbers. I will be reading now from the numbers on the left, which should solve the problem going forward.
Thank you.
So this is the Abraj Holdings organizational structure, which the defendant was ordered to disclose. If we look at the top left hand side, we will see in blue there Abraj Management Limited. So this is the entity that the money was paid to, and then on top of that you see Abraj Holdings, which we will come to later on. If Your Honor looks down to the bottom, you will see a number of subsidiaries, and then at the very bottom there are a group of funds in yellow and green. So what this document tells us is that Abraj was engaged in the business of private equity, And private equity is a process where an investment manager like AIML would set up funds for different investment purposes, and then they would invite investors to purchase units in those funds. Yes. So that's the business model of Abraj. So when an officer of Abraj, like Mr. Naqvi, tells an investor, please transfer 10 million dirhams to be invested on your behalf on a discretionary mandate basis, we say that this means that I will, or the company will, purchase units in some of our investment funds. And the word discretionary here, it's an industry term, and normally in the financial services industry, this means that the manager has the right to choose the type of the investment without going back to the client.
Yeah, I'm familiar with all of that, Mr. Bajmal. Just looking at the yellow and green companies, 3, if you look at the key at the top for yellow, 3 is GPs, 4 is funds, LPs, LLCs, and others. LPs is presumably limited partnerships, is it?
Correct. The structure, as I know it, involves normally a general partner and a limited partner, and then that's how these funds are set up.
Yes. Yeah. Right. So all the funds are limited partnerships with a general partner who has the discretionary power to invest on behalf of all the other limited partners. Is that the plan?
Yes.
So your client, if your client was familiar with this, and I don't know whether he was or he wasn't, he would have expected to become a limited partner in one of these funds, would he?
That's one way this could have been carried out. Another way, which comes out in the correspondence, is that the funds, they have units. So the funds are divided into units, right, and then investors are allocated units within the fund.
Okay. Well, that would be commonplace in a fund of any kind. Yes. Understood.
Yes. So so that's the expectation for that any investor would have when receiving such a letter. Now, we say that this statement was fraudulent because there was no investment made whatsoever. If we and on this we rely on a host of documents, the first of which is the emails that were disclosed in the Deloitte report. And again, I'm going to use the term Deloitte report here loosely because I will make submissions on the admissibility issue, but I will address the content of the report now. So in the Deloitte report, Deloitte, in their capacity as the liquidators of Abraj, who have access to the company records, we had asked them a set of questions, and then they provided responses within that report. And in answer to question number Q, and I'm going to take Your Honor to that answer. I will make sure that I get the right reference now. So this is in volume 5.29. And it should be at 2575.
Yes.
So in this, on this page, I'm just one moment, Your Honor. So if we look at there was a direct question which was set out by us to the liquidators, which says, were there any units or any other form of ownership rights in the fund that held the stake in Careem ever officially transferred to Mr. Girgawi or Muzoon Holding LLC? And then the answer there is no. Per the phase 2 section above, the allocation to Mr. Girgawi was reflected in Abraj internal accounting records only. No units or ownership rights in Careem appear to have been transferred to Mr. Girgawi at any time. Just by way of background, Careem was the investment that was communicated to Muzoon's team as to have been made at the time, and these statements were communicated by way of the email dated the 2nd of September 2016, and then the email dated the 16th of March 2017. These are the emails, that included the statements of accounts, which we say were fictitious. So if we look at I'm not going to take another there because the reference is there. However, I've summarized them in my skeleton. So in the email that's dated the 2nd of September 2016, we have Mr. Lakani, who's an employee of AIML, and the defendant writes to Mr. Prasad, who is an employee of Muzoon, confirming that USD 1.5 million dollars of the claimant's funds were invested into the transport company Careem, and that the investment is valued at USD 2.85 million as of the 30th of June 2016, and that the remainder will be allocated to further opportunities. So this email shows us the first communication after the money was received. What was the claimant informed of? So the claimant was informed that there was an investment into Careem. We now know from the liquidator's answer that there was no such investment. And this email...
Can I just ask you a question here, Mr. Bajmal, because this seems to me to be pretty important in the overall context. Just assume for the moment that I can take it on the evidence that no individual units in any one of the green funds was ever allocated to your client in a formal sense. If the position was that although there was no units actually issued in the fund, average, and I use that term generally without any distinction between any company or any particular fund that they held, average did allocate in its books, let's assume 1.5 million. I think on the figures it works out in the end that something like is it 2.83 or something of that kind. If they did allocate it internally, then the position would be, wouldn't it, that there was an investment and that they would be deemed on the face of it to hold that on trust for your client. Is that right or wrong?
I say it's wrong, Your Honor, because because had a real investment been made, yes, the claimant would have had ownership units in standalone funds, and even after the collapse of the Abraj group, these funds.
I understand that. I understand that. If there had been, then it would be possible for him to say, well, I've really got it, ownership, proprietary rights. So I understand the difficulty. But what I've got is just a few odd emails. If what your client had expected was to be told that he'd got 25 units, 65 units, whatever it is, in this fund, that fund, and the other fund, why isn't there any correspondence relating to that? All we've got is these terribly general statements that we've made an investment for you in Karim, and it's very vague indeed, isn't it?
It is, but what we submit, Your Honor, is that on the balance of probabilities here, there is the onus is on the claimant to establish that the funds were paid and that it was paid for a specific type or for the purpose for which the payment was made. And the purpose here was, as in the defendant's own words, to invest on his behalf. So yes. If there was no investment at all, then we say that that is a deceitful act in itself.
But hold on. The first thing you have to establish is that there is deceit at the point of inducement. No doubt, he says, we've got the email that you just referred me to. Send me the money and I'll invest it on your behalf under a discretionary investment mandate. So that much is clear. Now, what you have to show there's a deceit is that at that moment there was no intention on the part of Mr. Naqvi to invest any money on behalf of your client. Isn't that right?
Yes. Yes. Yeah. Correct.
Now, how do you show that there was no intention at that stage?
Because had there been an intention to carry out the investment in a normal way, then the defendant would have complied with the regulations. And this is something that I will address in the next section under inducement. However, in general terms, AIML was found to have carried out activities within the DIFC. Now, whether that was licensed or unlicensed, we say that it should now be held accountable against those rules. And these are the rules of the DFSA. And the rules of the DFSA require that client funds should not be commingled with any other funds and should be held in separate client accounts that are clearly identifiable. Therefore, any investment manager acting in accordance with the rules or in accordance with the general principles of honesty would place those funds in a separate client's account until an investment opportunity presents itself. But what has happened here is that we know from the liquidator's response is that the claimant's funds were commingled immediately upon arrival to AIML's accounts, to the extent that they were likely used for other purposes. So that is why we say there was no intention from the beginning to carry out the investment in a normal way. The
key to what you're saying there is in the normal way, isn't it? And this is the point I've been discussing with you for a bit, which is whether one can read into the documents that you have produced the notion that it would necessarily be investment in a fund of the kind that you've mentioned. In which case, I would have expected there to be an exchange of emails saying, "Hello, what's the name of the fund? What shares have I got in the fund? What units or whatever?" And all I've got is just half a dozen of these documents. I'm being frank with you, Mr. Bajmal. I'm very sympathetic to your client because of all the background that I've understood. But I'm finding it very difficult to see how I can really, on the balance of probabilities and on this evidence, make the sort of finding you're asking me to find.
Well, perhaps we could have a look at another set of emails which will show the defendant's internal discussions after the funds were received. These are the so just to continue with the sequence of the facts. After these representations were made, so there's all the way from the September 2016 email to the March 2017 email, then based on, we say that these emails encouraged the second payment of 10 million on the 17th of May 2017. And the documents that were the emails that were disclosed by Deloitte tell us this is at 529, and then it's at 2583 it should be.
So July the 16th, is that what I'm looking at?
You should be seeing a set of emails.
Yes.
Yes.
Starting with Saturday, July the 16th.
Correct. Correct.
Yeah.
So the first email. So just to remind you of the set of characters here. So we have Mr. Rafiq Lakhani, who's the head of finance in Abraj, and then we have Mr. Mustafa Abdul Wadud, who is a senior management officer, and then we have Mr. Naqvi himself in this chain of emails. So we can see at the top, just one moment, Your Honor, I'm going to find the correct page. Yes, Your Honor. So what we have here is a chain of emails, which is the discussions that took place between the defendant and his staff after the receipt of the funds. And the first email that was sent by the defendant himself to Mr. Abdul Wadud was in June 2016. So this was some 7 months after the funds had been received in November 2015. And in this email, the defendant explains to Mr. Abdul Wadud that this issue is a ticking time bomb, and we say that this means it's a ticking time bomb because the funds were never invested and had been commingled. So he asks Mr. Abdul Wadud to deal with the situation. And then on the 16th of June, Mr. Abdul Wadud writes to the defendant with a proposal. His email reads as follows. He says, "We can use the vehicle that was put aside for Kareem. For other investments, we can look at AH, Abraj Holdings positions, and either transfer against cash or synthetically hold the underlying, and then there's a reduction, along with new investments such as redacted, and then we'll try and compose a portfolio. What is the deployment period? Should we look at 100% within 2 years of commitment?" And then the defendant responds on the same chain, yes. So, Your Honor, what we say is the evidence of deceit here, is the clear use of the words synthetically here, because if this was a real investment, you wouldn't call it a synthetic investment. Synthetic is essentially something that is not real. On the same email chain.
Can we just go through that email and tell
Yes.
me what you say he's actually saying? So what does "we can use the vehicle that was put aside for Kareem" mean? Is that talking about a particular fund?
Because we don't have evidence from the defendant or Mr. Abdul Wadud, what I say is my reading of the document. So my reading of this document is that Yes, he is referring to some fund, and he is suggesting that there will be this synthetic investment, in the sense that we will just show, without actually purchasing the units and registering them in the name of the investor, that we will just make an entry in our books that this much has been allocated.
Hold. If we go to the email of the, well, it's a bit later, that's the 30th of August. But what it appears to be talking about is, at this stage, all your client is being told that there has been an investment of a certain amount in Kareem, and the rest has been uninvested. So he would have expected that to be remaining in cash, one assumes. Now, looking at this, he's talking about, on the 16th of July, an investment in Kareem, where he says we can use our fund. And then he's talking about other investments where we can look at what Abraj is holding and make transfers against cash. So that's a real transfer, one would assume, in the sense that you mean, or synthetically hold the underlying, which means presumably that it would be allocated in their books, but no formal transfer would be made. Have I understood that right?
Partially, yes. I would like to add that, so the context of these emails, these are the discussions that took place internally between the defendant and his staff before the emails were sent to my client.
Understood.
Yes. So in essence, yes, there was this suggestion that what was ultimately communicated to my client was that there was an investment made into Kareem, and that investment had gained a profit, because the amount in the email is, yes, and then that the rest was being held as a cash amount within the company. So,
and in the end, the statements of account say that the Kareem investment was sold and a profit was raised.
Correct.
So
correct.
If everything had been as your client was being told, there would be a cash sum sitting at the end of the day, which you say would have expected to be in a separate account, not commingled with general funds.
Correct.
But it wouldn't be an interest in any particular fund. It would simply be a cash sum that ought to be in a separate account.
That is correct. The investment into Kareem would take the form of units into the fund.
Yeah, but that had been sold. Supposedly, that had been bought and sold in the way that private equities do, and a healthy profit had been made, according to Abraj.
Precisely, So this is the false information and false that being made. So taking their communication at face value, it would have meant that there is a client account somewhere where the claimant's funds are sitting, and these funds are not commingled with any other funds as is required by regulation, and that these funds wouldn't be affected by the collapse of the Abraj group. This is I think Your Honor got the idea.
I've got all the points, because on the face of it, from what you say, there's the clear breaches, the DFSA rules and so on and so forth. The funds haven't been used the way they were. No question at all that AIM, IL and so on are in breach. Your client has no doubt an extremely good claim against any one or all of the Abraj companies. But fat lot of good that will do you if there's no money there to be had, which is why, of course, you go for the individual. But in order to succeed against the individual, you've got to show, it seems to me, either a fraudulent intent from the word go, so that there is a misrepresentation of intention by him at the outset, which induces the original investment and the second investment, or alternatively, and this I don't think is pleaded, but is mentioned in your skeleton, that there is dishonest assistance in a breach of fiduciary duty by the company, one company or the other, because he's involved in it and effectively he's giving the directions to his inferiors as to what to do. So I think those are the ways the case has to be put. And as I say, I'm very sympathetic to you, but I'm not sure that you've got enough to go on.
Well, Your Honor, we need to separate between the first payment and the second payment.
Yes.
Because with regards to the second payment, I can see that on the face of it, the invitation letter on its own might not lead to a conclusion that the statement was false. However, read together with all the chain of correspondence that happened afterwards and the facts that came into light after the collapse of the Abraj group, one could conclude that that statement was false from the get-go. With regards to the second tranche of the payment, I've just shown Your Honor the emails, which clearly show that the information that was communicated to the claimant before the second investment was made were false. So with regards to the second payment, at least, there is no unclarity about the falseness about the statements, and it's plain on the documents in light of the responses from the liquidators.
Right. Well, I think you're going to have to take me through those documents in a little bit more detail to make that point good.
Yes.
I say we need to, I think, look at it literally phrase by phrase as to what they're really saying.
Yes.
So would you mind doing that?
Yes. I will just take a second to go back to the beginning of the document.
Yes, I think we may need to go through these in sequence. And what slightly troubles me about all this, Mr. Is that all I've got is just these documents. Your clients don't seem to produce any documents at all, and I would have expected Mr. Prasad, if doing his job, to be chasing this, and there to be a whole lot of correspondence going backwards and forwards saying, tell me where the money is, tell me what I've invested in, what units have I got, what fund is it, what's the investment in Karim, and so on and so forth. And I don't get any of that, do I?
Unfortunately, Your Honor, there aren't any other correspondences. Maybe, yes, in hindsight, maybe more would have been expected of Mr. Prasad. However, the nature of the stature of these are my instructions that, you know, there was nothing else. There's nothing else for us to disclose. These were all the exchanges. I'll just take a moment, Your Honor, just to go back to the beginning of the document.
Thank you.
Yes, Your Honor, this should be in page 2583 of the bundle, which is 5.29, the volume.
5.3, yeah. So we're starting on Saturday, the 16th of July.
Correct. This is the first email from the defendant himself to Mr. Abdul Wadud. He's saying, this had been in the chain will then at the bottom show us how this came about, but he's referring to above. We can see in the subject box it says Muhammad Abdullah al-Girgawi, so we know that this chain relates to these facts, and then he says, this is a ticking time bomb. We need to allocate it into investments. Karim was one. Can we please deal with this? To put this into context, this is July 2016, 7 months after the first 10 million was paid around November 2015. So up to that point, there was nothing done. Then if we go to the email from Mr. Abdul Wadud to the defendant on the same day,
Yeah. Which is that's the one we've just been looking at. We can use the vehicle that was put aside for Karim.
correct?
Yeah. Yeah.
And then if we
and then it's talking about other investments which were never made, even on their case.
Correct. And then
the bits that are redacted, why are they redacted?
I believe these are names of other companies like Karim, and my understanding.
Okay.
Yeah. My understanding is that the liquidators didn't want to disclose the names of those companies because they hadn't been communicated to us before.
Yes, I see.
And then we see another email, a chaser on the 2nd of August 2016. So in between, it seems that nothing had happened. And then Mr. Rafiq Lakhani writes to Mr. Abdul Wadud on the 2nd of August 2016. And then he writes, and that's in reference to the chasing emails from Mr. Prasad. He says his finance manager has asked for the latest valuation of the portfolio, for which I have committed to provide by next week. And then he says,
hold on, I've lost that one. Where's that one?
This is on 2583. It should be at the top. 2582. My apologies. So there's a big reduction in the middle of the email.
Oh, right, okay. Yes.
And at the top, it says, dear Mustafa, AMN, Arif Masood Naqvi, the defendant, has asked me that the portfolio should comprise of investments in Karim, and then redacted, and then the balance should be shown as cash. So that's the second bit. And then if we go up the chain to
I'm sorry, I'm being very slow here. AMN is who?
AMN is Arif Masood Naqvi, the defendant.
That's Naqvi, yeah, okay.
Yes.
Naqvi is Arsenal, yeah. Balance should be shown in cash, okay. So that's their apparent internal decision, yeah.
That is, yes. So basically, what we're looking at is Mr. Prasad chasing for an answer, and then the team is discussing how to give him an answer.
How to answer, yeah.
Yes. So then in response to this last email, Mr. Abdul Wadud writes back saying would almost be better to synthetically mirror that through documentation that says that our share of our LP position has transferred the Karim portion of its interest to the Gergawi vehicle. So we effectively, between quotes, sell our economic benefit from Karim to the tune of the size of the Gergawi vehicle. Please advise.
Yes, God. What does explain what you say that means?
Okay, in the Gergawi vehicle, in our view, is Muzoon, because that entity had been involved in the communication from the beginning. So we say that this means that everyone had an understanding that this was the vehicle that was going to carry the investment. Right. So that's one part of the email. So the first part of the email was what our understanding is that it, again, Mr. Abdul Wadud is insisting that the entire investment is done on synthetic or fraudulent fake basis. So he suggests that to explain this, Your Honor, we need to understand that normally in some of the funds, Abraj had its own entity, which
Yes.
also owned units within a fund.
Yeah, absolutely.
So what Mr. Abdul Wadud suggests here is that we can create documents that show that we have sold some of our own or our subsidiaries' own units in the funds and show as if we have sold. But again, he uses the word, this term between quotations, which in our view donates that it is not meant to be carried out as a sale, but this is rather a fictitious accounting entry. And then if we go up in the same page.
How much does that argument depend on the use of the word synthetic, which is used in any number of different ways?
It's only partial. It's not completely dependent on it, Your Honor, because we do have a clear statement from the liquidator saying that no units had been transferred and no investment had been made. So the use of the word synthetic here only donates the clear intention of that there is no confusion as such. It's not a matter of the staff members being confused about something. And what we say this means is that they knew clearly that they were creating fictitious entries and providing false information. Which by the way, Mr. Abdul Wadud had admitted to and pled guilty to in US proceedings.
Of course, not in relation to this specific.
Correct, as a general conduct, yes.
Yes, a general way of doing business, yes.
Yeah. So that's why we say, Your Honor, you should read synthetic in that context, at least, that this is someone who carried out business in this manner.
And when the word sell appears in inverted commas, and again, that's a bit ambiguous, isn't it? What he appears to be talking about is a transfer in their books, which is actually what appears to have happened. Is that right?
We say that this did not happen because clearly the statements from the liquidators do not say that this has happened. Like even the suggestion that was being suggested in this email did not happen. Why? Because in the following email, then Mr. Lakhani carries out further instructions of the defendant, and so this was a suggestion that seems that was never carried out. So.
So where do we go next?
Yes, we just go to the top of that page. Just one, yes. So the same page. So the top part of the same page. So this is again, dear Mustafa. This is on the 30th of August. So the earlier email was on the 2nd of August, and then. On the 30th of August, Mr. Lakhani writes back with the final instructions to say, Dear Mustafa, as you are aware, we have to provide valuation of their portfolio by the end of this week. We had decided, i.e. Mr. Lakhani and the defendant, on giving them Kareem 1 million US and 1 million and something else redacted as 1 million, and then balance as cash for future allocation between brackets education etc. Now that we don't have redacted to be allocated, I suggest that we allocate Kareem 1.5 million and balance as cash to be invested in future investment opportunities. Please advise. So this was the final solution that they come up with, and then this was what was effectively eventually communicated to the claimant. So again, so this takes us back to the question of whether any of this was true or false, and we say it is clear that this was false, because no actual investment was made into Kareem, nor had there been, if there had been a purchase and a sale of Kareem and then a profit collected, this would be sitting in a client account, clearly earmarked in the name of the claimant. So this brings us to the end of the email trail. So with regards to the again, I'm going to repeat this point just for clarity. These emails show that the inducement for the second portion of the investment, the second 10 million, was clearly based on the information that was provided with regards to the first tranche of the investment, and one would expect that any investor, when such numbers are being reported, that it would be inclined to invest more.
So that all turns, so far as the communication with your client is concerned, on the 2nd of September email, we have allocated 1.5 million of your investment to Kareem. We're currently investigating further investment opportunities, right?
Correct.
Yeah, okay.
And then
he doesn't actually produce the money until the following May.
No, Your Honor. The way the facts went is that there was another email sent on the 16th of March 2017.
Yeah.
So this is on
volume
5.29, and then it's on page 255. It should be 2600.
Thank you. No, that's the decision notice.
My apologies, Your Honor. I will try to locate it now.
What date is it? 15th of March, did you say?
It said 16th of March.
16th of March.
Yeah.
Okay, yes, I've got that. I don't know what page that is, but
Yeah. 1 second, Your Honor.
yes, this is the one saying the investments allocated is 1.8 million.
Yes. So this email. Sorry, can we zoom this?
Sure.
Do you have a page reference for that?
Yes, it is. Should be 2560. No, so, no, 2550. My apologies. So in January of 2017, Mr. Prasad writes again and asks Mr. Lakhani, "Dear Rafiq, trust this email finds you well. Can you provide us with an update as at the 31st of December 2016 on the investment portfolio of H.E. Mohammed Abdullah Girgawi with Abraj? Thanks, regards." So if we go then down, no, up, sorry, the same page, then there's the response from Mr. Lakhani. It says, "Dear Krishna, subsequent to the below valuation update, the allocation of investment in Careem has increased by $300K as Careem drew down more money to fund its ongoing expansion. This takes the total investment allocated to you for Careem to be $1.8 million as at 31st of December 2016. The investment is valued at 4.46 million. So we can see the contradiction here in the sense that what Mr. Lakhani seemed to be saying in the September email was that there had been a profit already generated from some sort of buying and selling in the Careem. But what this email now seems to say is that the investment in Careem is still intact, and that there seems to be a position that is still held in Careem, and that this position increased because Careem made further drawdowns from the fund, and that the total investment is now at 4.46 million. So it was this email that we say further then induced the claimant to make the second payment, because the second payment was made on the 17th of May 2017, and there was a covering letter. I will find it in a moment. Yes. Yes, so you know, this is at 2552. So this is a covering letter which enclosed the check for the second payment, and it's addressed to Mr. Lafiq at Abraj, and then it says, upon instructions from H.E. Mohammed Al-Gargawi, please find enclosed a check of 10 million towards additional investment under the discretionary investment mandate. We request you to acknowledge the same. So we say that once the reports came out, the email came on the 16th of March, then there was an assessment made that, okay, this is a successful investment, and therefore further funds were invested.
Yeah.
The last email, which I would like to take your honor to, is at 2558.
Yeah.
And this is the kind of the final communication from Abraj to the claimant. So this is an email attaching a statement of accounts. So this is a 6th of April 2018. So that was right around the time when shortly thereafter the Abraj group collapsed. And attached to this email was a statement of account which had shown that there is that out of this investment there is an interest income of USD 6.19 million as of the 28th of February 2018, and then that was the last kind of position that was provided to the claimant. So this is, again, we say that this is another false document that was provided as confirmed by the liquidators.
Yeah.
Uh,
So
yes.
this,
Yes.
so these are the two documents that show interest of 321,896, and then the total what they should have had in hand on this basis was $7,445,154. Is that right?
Yes, that's according to that email. Yes.
Yeah. So that was the attachment. Yeah. Okay. I didn't see, and I'm not sure you've produced it, the figures that were attached to the earlier email, the one of the 16th of March 2017.
Yes, they are available in the bundle. I
Are
will
they?
provide.
Could you find those for me?
Sure.
Not now necessarily, but
yes, perhaps I can send them to the registry, or I can after the break, perhaps. Yes.
okay. All right. Okay. Well, that's helpful. I've got the sequence now. Thank you.
Thank you, Your Honor. Now, I would like to move to the second or the third limb of the test, and we say this is plainly satisfied on the documents, so that we have to establish that the claimant did rely on the fraudulent statements made by the defendant, and we say that it is plain on the face of the emails we just went through that the defendant was personally involved in the communication. He gave instructions to his staff members on how to respond, and therefore he was a direct personal participant in the fraudulent statements, and that it is plain that the claimant relied on those statements when the payment was made.
Two different questions there. When you say it's clear that the defendant was involved, all of these emails emanate not from Mr. Naqvi himself, but from one of his minions. So on what basis can you ask me to infer that it was his instructions?
We've just seen an email, Your Honor, where Mr. Lakani says AMN informed me, and then the beginning of the email chain was also initiated by the defendant himself, where he says this is a ticking time bomb and so on, and he was copied on each and every one of those emails. And also we know that ultimately it was his instructions that took over the suggestion that was being made by Mr. Abdul Wadud. So we say that it's his instructions were, although the final email may have not been sent by him, but it was orchestrated by him.
Yes, all right. And so far as reliance by the claimant is concerned, I've got obviously the fact that payments were made and so on, the second investment was made. I don't have any direct evidence, do I, from Mr. Al-Ghagawi?
No, because he wasn't involved in these communications directly. So the person who was involved was Mr. Prasad, whom had provided a witness statement.
Well, can you show me the part of his witness statement where he says that he relied on this in order to make the second investment?
Not to that extent, Your Honor. No, he does not testify to that. This is a conclusion that we make from the documents. He hasn't testified to that effect.
Right.
And just to before we leave this topic, Your Honor, you had mentioned that you had a concern with the lack of correspondence or follow-up from Mr. Prasad, and on this point, we would like to draw in our attention to the authority of Hayward and the Zurich Insurance Company, which is at paragraph 86 of my skeleton, and this authority.
Well, if I understand, that it's no defence to say you're a fool. The other man was a fool to be deceived and didn't play. I'm not troubled by that at all. It's so that you don't need to address me on that. I mean, you asked me to infer that Mr. Prasad must have relied on this, because otherwise, why would he have sent the money? He's getting nice noises as to what's happened to the previous money, so he sends more. It's a natural inference, you say.
Yes, it's commonsensical. Yes, that if someone is presented with such evidence, but just to be clear, Your Honor, as well, just to be precise on the documents, that in the covering letter that we just saw, Mr. Prasad is not saying that he had made the decision to send more money. He says that Mr. Girgawi had instructed this money to be sent. So he was the messenger, if you will.
Yes. Okay.
The last limb of the test is that the claimant needs to establish that he suffered a loss as a result of the fraudulent statements made by the defendant. And again, we say that it is plain that as a result of these deceitful acts, i.e. not having purchased any units, not having parked any excess cash in
Can't hear you. Can't hear you again.
Is it okay now?
Yes, thank you.
Thank you.
So we missed the last couple of minutes.
Yes. So we say that the claimant suffered a loss as a result of the deceitful acts of the defendant, because had any units been purchased in any fund, the claimant would not have suffered a loss, and had any unutilized cash been held in a designated client account, again, the loss would not have been suffered, because essentially the way private equity companies are structured is that they're designed to be independent of the underlying funds and assets. And what, in the sense that any collapse of the investment management companies such as AIML would completely go, would not affect the underlying assets being the funds. In this case, because of the deceitful acts that took place, because Mr. Naqvi decided not to play by the rules, the defendant, the claimant suffered this loss. The other point that I wanted to address Your Honor on is a defense that was raised by the defendant, to the effect that any deceitful acts that may have taken place or were carried out by Mr. Naqvi were not to his personal benefit, that any acts that he carried out should be attributable to the corporate entity because he acted.
Well, I don't understand that. I don't need you to deal with that unless Mr. Patrick Joyce addresses me on it. On the face of it, if an individual is involved in deceit, he's liable whether or not the company that employs him is liable, and it doesn't matter whether he benefits or not.
Thank you, Your Honor. That's
well, I'll
clear.
wait to hear. If Mr. Patrick Joyce wants to address me on that, I'll give you a chance to reply, and if there's some point I've missed. Thank you. Yep.
Thank you. In any event, I've stated my position in the skeleton, and I've provided Your Honor with some authorities on that. This means that I need to move to the second ground for liability, which is the inducement. So under this heading, we say that the defendant is liable on a standalone basis, regardless of how the court views the question of deceit. We have a standalone ground under Article 32 of the DIFC Law of Obligations, which reads as follows. A defendant is liable to a claimant if he knows that a third party owes a legal obligation to the claimant and he intentionally induces that third party to breach that obligation and the claimant suffers a loss as a result of the breach. In this instance, the third party is AIML, so it's clearly the defendant created a legal relationship by way of sending the invitation letter, that is the October 2015 letter. He, as the officer of AIML, created a legal relationship between the claimant and AIML. And we say this legal relationship is one of an investor and an investment manager. As I mentioned earlier, we say that since AIML was carrying out activities in the DIFC, it should be held accountable against the rules that would have been applicable to it had it been licensed in the DIFC. And those rules are stated in the DFSA Code of Conduct, and then the DFSA Collective Investment Law. In particular, these go from rule number 6.4.2 to A5 3.5. I will not take your honor through each one of them. I've provided them in the authorities bundle. However, I will just walk your honor through what each rule requires an investment manager to do. So we have 6.4.2 of the Code of Conduct business model. It says, when an authorized firm agrees or decides in the exercise of its discretion to execute any transaction with or for a client in an investment, it must provide best execution. And then rule 6.13.1 says, an authorized firm must treat all investments held or controlled on behalf of a client in the course of or in connection with carrying the investment business as client investments, i.e. that there should be a clear separation between any investments carried out on behalf of the firm itself and those investments carried out on behalf of clients. And then in 6.13.2 says an authorized firm must hold, which holds or controls client investments, must have systems and controls in place to ensure the proper safeguarding of client investments. And then the following rule says, where an authorized firm holds or controls clients' money, it must ensure, except where otherwise provided in COB section A5.5, that the client money is paid into one or more client accounts within 1 day of receipt. And then the rest of the rules follow in the same line, i.e. there is an overriding objective identified in these rules that requires a separation between client funds and firm funds, and there is also a requirement for client funds to be paid into separate clients' accounts within 1 day. We say that the defendant has caused AIML to breach all of these obligations, and that as a result of this breach, the claimant suffered the loss. And the intention of the defendant is clear from two sources. The first source is the emails that we reviewed a while ago, which show that, again, there was no payment into client accounts. And the second source is the Deloitte report, which tells us that there was no such cash holding, there were no such client account created for the claimant, and that as soon as the funds arrived in the AIML account, in both situations, they were, or with regards to both payments, the money was immediately commingled with other funds and then dispersed in a manner that cannot be traced by the liquidators. So we say that this is a clear breach of the duties that were owed to the claimant as an investor, and that this breach was intentional on part of the defendant, and therefore he has induced AIML to carry out this breach, and for this reason he should be personally liable for the loss suffered by the claimant.
Now, this is put on the basis of essentially inducement of breach of contract, the contract between AIML and the investor. So you're not, this is a different point from knowing assistance in a breach of fiduciary duty.
Correct, Your Honor. That is a standalone ground that was mentioned in our particulars of claim. So it was pleaded from day one. And perhaps, Your Honor, you're referring to maybe the English law version of what would inducement for a third party to breach its contractual obligations. This is slightly different, perhaps under the IFC law, because it is codified in Article 32, and Article 32 speaks of a legal obligation as opposed to. I take it that a legal obligation includes a contractual obligation by nature, but the IFC statute.
Well, I think that is primarily what it's aimed at, isn't it? You know, the law of obligations is essentially a law about contracts.
A legal obligation is when one signs a contract, he enters into a legal obligation.
Well, of course.
Yes, well, yeah. So whether the what we say is that simply the source can be a contract, the source can be a statutory duty. It does not matter.
Okay.
So again, this is a standalone ground, and we say that liability on it is plain and simple, and it does not require a finding in our favor in terms of deceit. It only requires showing that there was a legal obligation, and which was created by way of that letter, and then we need to show intention, which we say is clear from the correspondence and the statements of the liquidators. That brings me to the end of my submissions on the main topics. I'm mindful of the time, so I will use the rest of the. My plan was to use the rest of the time to address some points that arose from Mr. Joyce's skeleton and the notice of admissibility of documents that was sent. Is this something that Your Honor thinks that would be fit to be done now, or after Mr. Joyce delivers his submissions?
Well, why don't you make your submissions now, and we'll see. You'll have a right to reply at the end of the day as well. So, but let me hear what you say about it now.
Thank you.
I have a real problem with the DF SA material for two reasons. One is the essential reason that Mr. Patrick Joyce gives, which is, on the face of it, it's not admissible in the context of a dispute between your clients on the one hand and the defendant on another. It's simply the conclusions reached by a disciplinary body, and it would be the same if it were the conclusions reached by a court as between other parties. The second thing is the difficulty that none of it is directly relevant to the facts of this case. What you see is a pattern of conduct, so that there's a problem of relevance. So you can address me on that if you want, but on the face of it, I can't see how it helps me much. The Deloitte report is much more interesting and much more to the point, because they have addressed themselves very specifically to this. Mr. Patrick Joyce makes a number of points about their disclaimers of liability and not relying on it and so on and so forth. I don't have any difficulty at all in relying on the emails that have been produced, although I can't be sure that they're comprehensive, and indeed Deloitte can't be sure they're comprehensive. They've done their best search that they can with keywords and so on and so forth. But I would like you to address me on Deloitte's answers to the questions that you asked, and in particular the evidence they give about commingling of funds and so on and so forth.
Yes, Joran, so if I may, I will start with the question of admissibility of the DFSA decisions. And yes. Firstly, I would like to point out to the fact that this issue of admissibility of the document would have been more, would carry more weight as if if the claimant's case rests on this document. However, we say that in any event, regardless of whether DFSA decision, there are multiple sources to the information that we rely on, and it is not solely dependent on the DFSA decisions. So that's one point. The second point I would like to note is that in the defense, the defendant had relied on the earlier DFSA decisions to make some arguments. If Your Honor, have the defense is at 5.04, and then it starts at 1.545, if I'm not mistaken. 1.541.
Yes. Yeah.
One moment. Yes, so if we go to paragraph 11C of the defense.
Yes.
So firstly, the defendant is making an argument that is based on some of the statements that were made in the Deloitte report. So he's relying on the document that he wishes to be not admitted at the moment, which in my view is enough for the admissibility issue to be decided against the defendant. And then I would like to also show you on another paragraph. I will find it. Yes, Your Honor. So we're looking for paragraph 10. If we look at the last line of paragraph 10, it says, this is borne out by the claimant's own pleadings, the decision notice of the DFSA cited by the claimant, and the superseding indictment filed the government of the United States, all of which name a number of individuals as decision makers of the Abraj group. The present claim singularly brought against the defendant is misguided. So the defendant again is making an argument by reference and in reliance of the DFSA notice to say that I should not be held personally liable alone. There were other people as well, as evidenced by this document. So that's that on this in this point. Now I'll address the legal issues raised by the defendant, and in a nutshell, what the defendant relies on is the authority of SIMS to say that like a decision of the Solicitor's Disciplinary Tribunal in the context of SIMS, the DFSA decisions should be treated in the same way the SDT's decision was treated in SIMS. And we say that this is wrong because of a number of reasons. The decision in SIMS rests on the previous principle in Hollington, and Hollington is a controversial principle that was applied throughout many cases, applied and disapplied throughout many cases, and many exceptions were created throughout the process. And with that, we would like to refer Your Honour to two cases where Hollington was not applied. So the first case is the case of Tuan Guanste and the General Medical Council. This is available at volume 1.7 of the authorities bundle at page 29. I'm not going to trouble Your Honour with going to each page now. I'm just going to provide you with the references if that's okay.
I'm looking for it, but which case is this?
This is the additional authorities bundle, not the main authorities bundle. Yes, and this is volume 1.7, and it should be at page. It starts at page 29.
Unpronounced name. Yeah.
Yeah, I think the right way is Tuan Guanste. That's my best attempt yet.
Yeah, good attempt. Yeah.
Yes. So this was a case, Your Honour, about a doctor who was alleged to have committed a medical malpractice which led to the death of a child. And in that case, the medical board had given a report which outlines their views with regards to the professional malpractice that was carried out by the doctor. And in this context, the court did draw a distinction between on the basis of the facts, and the court did allow the document to be admitted on the basis that this is a document that is that it is not adversarial in nature. The other case that
is there a particular part of the judgment that you rely on as justifying the
yes
possibility?
Yes, it is at 38. It's at paragraph 38 of the judgment. Page 38. I'm sorry.
And that would be
So for you, Your Honour, this would be page 44 on the other numbering. Yeah, so this is paragraph.
Yeah, I'm just looking at paragraph 28 onwards.
Yes.
Just give me a moment to look at these.
Sure.
This is all about admissibility for the tribunal itself, not admissibility in the court, isn't it?
No, it is. There were two documents, Your Honor. There is the report of the medical board, and then there was the coroner's report as well, and they were included. The coroner's report was included as part of the medical board's decision. In the beginning of the judgment, there is a citation of the findings of the report, and they speak about the various breaches that the doctor has committed.
Tell me which paragraphs you rely on.
Yes, just one moment, Your Honor. Yeah, so if we go to paragraph 30, Your Honor, and then it starts, the reason I do not have the grasp.
Yes, but that's all about inquisitorial proceedings.
Correct, correct, and I'll come to that, because that my submission develops based on this. So if you give me 5 minutes, I'll go through the.
Yeah, okay.
Yes. So the second authority that we rely on is a local authority and M. Again, I'll just build the entire argument, Your Honor, and then I'll take you to any judgment you would like. The essence of all of these cases is that there was an exception that was drawn with regards to any process that is inquisitorial in nature, and that the documents that were held to be inadmissible or should be inadmissible are decisions that carry some adjudicatory value. And we say that on the face of it, the DFSA decisions are not of this nature. And the reason is because on the top of the decision itself, if I may take Your Honor to that, it's at page 2600 of the bundle. So if we look at the top of the document, it says this decision notice has been referred to the Financial Markets Tribunal, where the parties will present their respective cases. Any findings in this decision are therefore provisional and reflect the DFSA's belief as to what occurred and how it considers the conduct should be characterized. The FMT will determine what, if any, is the appropriate action for the DFSA to take and remit the matter to the DFSA with such directions as the FMT considers appropriate to give effect to its determination. The FMT's decision will be made public in due course on the FMT section of the DFSA website. What does this tell us is that under the DFSA rules, there's a second tier of an adjudicatory phase that takes place after a DFSA decision notice is issued. And in this instance, Mr. Naqvi did in fact make a referral to this tribunal, and the matter is pending before this tribunals at the moment. So what we say is that the decision in a local authority and M clearly states that if a decision is of an administrative nature, then it should be admissible. So what we say is that the DFSA's decision is an administrative decision, and anything of an adjudicatory nature where the parties will present their cases, that is something that will happen at the higher tier, at the level of the Financial Markets Tribunal, and therefore the principle in SIMS does not apply. The second point I wanted to address, Your Honor, on is the fact that the DFSA decision itself is not a decision of a professional body, because in SIMS, the Solicitor's Disciplinary Tribunal is a body that oversees or regulates certain members of a certain profession. The DFSA does not regulate a specific profession. The DFSA is a body that regulates financial services at large within the IFC, and therefore we also submit that Your Honor should draw a distinction between the two bodies. Other authorities that I rely on in this context as well include Richardson and Rohan, which is at volume 1.8 and on pages 56 onwards. And again, this authority repeats the same conclusion that any decision of an inquisitorial nature should be admitted, and we say that the DFSA could also, the DFSA decision notices can also be held to be of inquisitorial nature, because they inquired into the state of affairs of the Abraj Group, and the DFSA made certain observations and factual conclusions. Whether that leads to the imposition of the fine itself does not make this decision not inquisitorial in nature. So these are my submissions, Your Honor, on the question of admissibility. I will perhaps after the break, I will provide Your Honor with references to specific paragraphs in each judgment, just to make it easy to find them.
Yes.
I have about 5 minutes left, which I will use to address the question of capacity, because this was one of the issues. Before I do that, I would like to address the Deloitte report issue,
Yes,
because
I'm much more interested in that, because it seems to me you need their evidence where you don't probably need the evidence. You don't need the DFSA reports anyway.
Thank you. And perhaps if I can't finish by 2, then this is already in principle agreed by between the parties, that I may take some time after the break if needed.
Well, it would be better. It would be better if you addressed all your submissions on the Deloitte report now, so Mr. Patrick Joyce can deal with them. I'm just telling you, I don't think there's anything very much, is there, in your skeleton about it?
Because there was the simultaneous exchange of skeletons, so
yes. Okay. Yeah. All right. Well, Deloitte. Yeah.
Yes. In essence, we say that the Deloitte report is not a third-party document such as the Bingham report or a decision issued by a third party. Put simply, the Deloitte report is a set of correspondence. It is, we had written a letter to Deloitte in their capacity as the liquidators and sought information, and we received a response. So the content, Deloitte chose to place their responses in the form of a report. However, in essence, the document is simply a response letter to our inquiries. So that's why we say it's one cannot expect the principles in Hollington to be applicable to the Deloitte report. That's on one hand. The second issue is that the defendant himself relied on certain passages from the Deloitte report in its defense, and therefore it is highly unusual for.
Can I interrupt a minute? Because yes. If you had produced for the trial the authors of the letter of the report, the Deloitte individuals, I don't see how there could have been any argument about admissibility at all, because they could come along and say, well, this is what we found in our capacity as liquidators. What you've got there is simply something in writing. I'm trying to recall quite what the provisions are in relation to documentary evidence in the DIFC, being far more familiar with the English Civil Evidence Act and so on. What's the position with regard to that? Is there an equivalent Civil Evidence Act in Dubai, or are documents simply taken as being evidence of their truth unless there's objection established to the contrary?
I will answer your question, but before I do that, this defense was never raised by the defendant. In essence, there was no question of the objections that are raised as to the admissibility of the Deloitte report do not arise out of the defendant saying that we had failed to present them as witnesses, or that they should be present as witnesses. So that's my first response. With regards to your question, I'm afraid I don't have the answer on the top of my head, so I would like to research it and address your Honour on it separately.
But let me tell you what my provisional view is, Mr. Bajmal, and Mr. Patrick Joyce can address me as well. But I say, if the two liquidators had come along and had given evidence before the court in orally and said, this is what we found in the documents, there was no separation of accounts, there was commingling of money, and so on and so forth, I can't see on any basis why that wouldn't be admissible. So my only issue really is with the fact that what we've got is something in writing, and the opportunity to cross-examine isn't there. So I have to take it with a bit more caution. And I do that also because of what appears on the front page, where they make a certain disclaimer of responsibility, which is what you'd expect from a liquidator in any event. So really, it's the question of what I would call in English law a Civil Evidence Act type of point, rather than anything else.
I understand your point, Your Honour, and just...
it's not a Hollington and Hewthorne point at all.
I agree, but this is not a defence that is raised by the defendant, neither in its defence nor in its.
No, it comes up simply in his skeleton and in his note on admissibility.
But the criticisms that are made in the skeleton with regards to the Deloitte report do not relate to this point, are not made on the basis of the point that Your Honour just mentioned. So the defendant itself is not pursuing this defense. And one more point on this issue. The fact that the defendant chose not to present his own witness testimony in response to the emails contained and the information contained in the Deloitte report also increased, because if we have an account from the defendant with regards to denying or providing alternative facts to the facts stated in the Deloitte report, this would justify cross-examination on both sides, and then the liquidators could be challenged on this evidence. But we don't have evidence from the defendant, and hence any cross-examination would be, not practical.
There's a cart before the horse issue here. The way the negative inference arises, you have to have prima facie evidence to the contrary, and then I would plainly be entitled to draw a negative inference from the fact that Mr. Naqvi has chosen not to turn up at this trial and give any evidence to justify his position. But there has to be a prima facie case against him. But the question which arises before we get to that in relation to the Deloitte report, never mind the emails, because the emails, speak for themselves. The question which arises to the Deloitte report, from what does not necessarily appear from the emails, is whether or not I can look at that in the context of commingling and so on and so forth. There's a certain amount in there, as you say, from the emails, but the questions that are answered are much more specific. I'm just having a look to see what is said in his note on admissibility by Mr. Patrick Joyce, and see if there's anything I need you to deal with.
I think this is in paragraph 3 of the notice of admissibility, and it simply says that Mr. Joyce intends to make further submissions to the effect.
Yes. All right. So, well, let's leave it there and see what Mr. Patrick Joyce has to say, and then you can investigate the point a bit further during the adjournment in any event.
Thank you. That sounds sensible, Your Honor.
Right. The plan now is to take a short break, is it?
Yes, so we'll break until 2:30 our time. It's half an hour from now, and then we'll proceed.
That gives you time to get a bit of lunch, does it?
Hopefully, yes.
All right. Well, that's fine. It's a bit early for lunch, but I shall have a cup of coffee in the UK. All right. Well, I'll see you in half an hour's time then.
Thank you very much.
Yes, half an hour's time is what in UK time 11:36. Sorry,
35.
Yeah, 11:35.
35 minutes past the hour, whether we're talking London or Dubai.
Thank you.
All right. Thank you very much.
Thank you.
Right. You ready to go, Mr. Patrick Joyce?
I am indeed, Your Honour. May I apologise for not having been. I had difficulty logging on, Your Honour, but I'm
That's
now
right.
on, and I can't seem to get out of being in a small icon down in the bottom right-hand corner. But you can hear me.
Yes, you're frozen, but I can hear you.
Well,
you're quite large enough on my screen, if I may say so.
Oh, well, that's fine. It doesn't matter that I'm a small icon on my own screen. I think that my learned friend was holding over some page references. I don't know whether he wishes, or paragraph references. He said that with regard to cases which he was referring to, Richardson and Rohan and other cases, my note was that he would provide references to paragraphs in each judgment after the break, and I'm more than happy for my learned friend to continue and complete his submissions in such form as he sees appropriate.
Your Honor, what I've done during the break is I have updated the authorities bundle with yellow markings on the relevant paragraphs of the authorities that we rely on, and we are sending this updated bundle with the markings to the registry and to the other side in a few moments.
All right, well, let's see where we get to on that, Mr. Patrick Joyce.
I'm obliged, but I would put down an immediate marker that obviously I cannot respond to paragraphs
Understood.
which are only highlighted now. And indeed, my learned friend has relied extensively on additional authorities which were not flagged up in his skeleton argument and which were provided, I think I'm correct, simply in the course of yesterday. I've done my best to get on top of that material, but all I do is put down a marker at this stage. And I don't wish to make a song and dance unnecessarily, Your Honour, but it is right that the court should know those circumstances. Your Honour, what I would...
Understood, but I'm rather expecting you to address me on the three authorities in a more general manner than going to specific paragraphs, but I don't know whether you're in a position to do that or not.
Well, Your Honour, I will do my best, and perhaps I can then confer at the end of my submissions with those instructing me if they feel that I've not had an opportunity to deal with the additional material that my learned friend has placed before the court. Then I would ask for permission to put in a short written note after the hearing.
Well, but just I've only had a very quick look at them, but they don't seem to me, at first blush at least, to be directly on point at all.
Well, that would be my broad submission, Your Honour.
Well, anyway, let's see where we get to on it. We should have a bit of time when you finish your submissions and after the further break to have a look at these matters, should we need to.
Your Honour, indeed. Your Honour, what I would propose to do is pick up some of the points which have been raised in oral submissions by my learned friend, and I hope pick up all of the material points which have been raised in oral submissions this morning, and then turn to my skeleton argument, and then invite the court to ask me, pose any further questions that the court has, obviously posing questions as we go through. Your Honour, looking at my learned friend's submissions, in very early course, well, he opened by reference to the pleading point, and Your Honour indicated that that was of less interest to the court than other points. Could I leave it on this basis, that I am, of course, happy to respond, if requested by the court, to any of the three cases that my learned friend referred to, Al-Hassani, SPI North against Swiss Post, and Patel and another against Patel and others, but in the absence of any specific request from the court to do so, I would leave it on the basis that there is nothing in my learned friend's pleading points, and I would therefore propose to move on. Your Honour, the next point was again in the course of what I would submit is a useful intervention from the court, namely in relation to the difficulties that my learned friend has in pursuing a case against Mr. Naqvi personally. And I listened attentively to what Your Honour said at the outset to see whether any light was shed on the concerns expressed then by my learned friend in his subsequent submissions, and whether anything that Your Honour said at the outset needed to be revisited. Your Honour said that Your Honour was entirely with my learned friend, or sorry, if you, or on the assumption that you were with my learned friend with regard to the pleading points. The question really was, how does my learned friend establish the facts that he needs to rely on to have a cause of action against the defendant personally? And leaving aside the general background, which Your Honour characterised as terrible shenanigans, I'm not going to venture down that path. I don't need to. Because Your Honour went on to say that the facts for my learned friend's case against this defendant don't get any help from the general matters, even if admissible, and of course I will come back to that. And Your Honour focused in my submission correctly on the only evidence which is before this court, which is the 4 emails, which I will come to. And of course, I bear in mind that having put that point fairly and squarely to my learned friend at the outset, the court came back in the course of my learned friend's submissions and invited my learned friend to do a line-by-line, phrase-by-phrase analysis of the emails in question. In my submission, my learned friend did not accept that invitation, or at least accepted it only to the point of reading what is on those emails without really addressing the point that your lordship or your honour had in mind, which was whether that establishes or goes anywhere near establishing a case against Mr. Naqvi in person. So I would respectfully echo those judicial doubts. I would respectfully echo the focus on what your lordship termed as a few odd emails. And of course, in that regard, we have nothing further from Mr. Prasad, if Mr. Prasad is indeed the natural person representing the proper claimant. But that, in my submission, is open to substantial doubt, which we have always raised throughout the course of the pleadings and our submissions. Substantial doubt as to the position of Muzoon Holding and Mr. Prasad as the natural person through whom Muzoon Holdings operates. Because in our submission, it is perfectly clear that the origin of the funds was Mr. Gagawi in person. It's a point made in our skeleton argument, and I'll come back to that when I go through that. But we have nothing further beyond the witness statements of Mr. Prasad, and really it's only in my submission the first witness statement which exhibits the emails in question, which has any materiality or admissibility. We have nothing at all from Mr. Gagawi at any stage. And of course, that makes, in our submission, insuperable hurdles for my learned friend's case in relation to reliance and the inferences that he invites the court to make. If one looks in our submission at the first tranche, that investment was made in November 2015, and the only material evidence with regard to that is the letter of the 29th of October 2015, and for that one can look at and I need to look at it on my screen, 2472. This is the letter of the 29th of October. Your Honour sees that it is on the Abraj Group headed notepaper. It is expressly addressed in person to Mr. Al-Gagawi, at Muzoon Holdings, but it is addressed to him. And all this letter says is subject investment with Abraj. Further to our discussion yesterday, please arrange to remit the amount of 10 million UAE dirhams to the following account, being the AIML account. As agreed, this amount will be invested by Abraj on your behalf, that is Mr. Gagawi's behalf, under a discretionary investment mandate. Now,
Well, do you accept there's an ambiguity about the letter referring to, because it does specifically refer to Muzoon Holdings, it's addressed to Mr. Al-Gagawi and Muzoon Holdings?
It is addressed to Mr. Al-Mazawi.
Supposing it had been addressed to Mr. Prasad, Muzoon Holdings, you wouldn't be saying it was Mr. Prasad's investment, would you?
Well, it would be, of course, Muzoon, which is represented by the natural person, Mr. Prasad, is the claimant. So I certainly wouldn't be saying it would be Muzoon's holdings, but there is no indication that this was other than a personal investment. And we know that from the opening words of this letter, further to our discussion yesterday. A discussion can only be something which takes place orally. An oral discussion can only take place between natural persons. The discussion was between Mr. Naqvi and Mr. Al-Gagawi, acting in person. And of course, we see that from the way in which the remittance is made.
Why would Muzoon Holdings then appear at all? I think isn't it open to me to infer that the discussion took place on the basis of this being his family investment company?
Well, if it's his family investment company, there is no indication that the money came from Muzoon Holding Limited.
I understand.
The money clearly came from Mr. Al-Gagawi in person. If the claimant, and this is a slightly different point, this is the wrong claimant point, if the claim were really to be pursued by Muzoon Holding, one would expect to see contra entries whereby if Mr. Al-Gagawi made a payment in person, as he plainly did, the transfer was made by him, the payment was drawn, the subsequent payment in 2017 was drawn on one of his personal accounts. If that was the origin, the actual source of the monies, but really it was intended to have been paid by Muzoon Holding, then Muzoon Holding would need to have reimbursed Mr. Al-Gagawi, and that would need to be shown in the books of Muzoon Holding. But there's absolutely no evidence of that at all, Your Honour. So the only evidence
is that realistic, Mr. Patrick Joyce? I mean, you know, things don't work in.
Well, in my submission, yes, it is, Your Honour, because a family office.
They don't formalise things in quite the way that you might hope.
Sorry. I didn't mean to talk across you. I think we may have a slight different sound. Well, Your Honour, to answer Your Honour's point, it is well known that in the Gulf jurisdictions particularly, but elsewhere, high or ultra high net worth individuals have family offices. But the family offices are there to act on the personal instructions of members of the family, usually the paterfamilias. They are agents for the natural person who is the ultra high net worth individual. That's the whole essence of a family office.
Well, I think that's such a generalization, Mr. Patrick Joyce, that it's that doesn't answer the question. Well, I mean, there are any number of potential arrangements between family companies and the paterfamilias, as you put it.
Well, then, Your Honour, the court can only go on the evidence that it has. And the evidence that it has is that the transfer was made by Mr. Al-Gagawi in person, and so was the cheque drawn in 2017. But as I say, and in my submission, the court, in the absence of any evidence of contra entries in books of accounts by Muzoon Holding, the court must go on the evidence which it has, and those are payments by Mr. Gagawi. But they are separate and distinct from the point that I take, Your Honour, to this letter for in the present context, which is to look at the basis on which the first tranche of the investment was made. In my submission, the first point to note is that this letter simply records the discussion which took place the previous day. And the only person on behalf of the claimant who can give evidence about that discussion is Mr. Al-Gagawi. We have no evidence of that discussion whatsoever. But in the light of that discussion, all this letter does is invite Mr. Al-Gharqawi, we say in his personal capacity, but whether in his personal capacity or on behalf of Muzoon Holdings, to make a remittance of 10 million dirham, and that it's going to be held under a discretionary investment mandate. That is not a representation of, that is not a fraudulent statement. It is not a misrepresentation. There is no evidence adduced by the claimant in relation to Mr. Naqvi's state of mind against which any fraudulent intent can objectively be judged in October 2015. There is
well, you wouldn't that's a question of inference, isn't it? I mean, you couldn't
well, to infer fraudulent
nobody on the claimant side could state what Mr. Naqvi's state of mind was. The question is, was he, by this letter, indicating an intention to make a discretionary investment under a discretionary investment mandate for whoever it was, when in fact he had no intention of investing at all? That's the question, isn't it? Because the only way the claim gets off the ground on misrepresentation in relation to this email, leaving aside the second tranche of investment, is if he is representing that he intends to invest and he has no such intention. That's the point, isn't it?
And how is that possibly spelled out from what we're looking at on the screen, Your Honour? It can't possibly be spelled out from that. And indeed, the claimant's own...
What do you say is involved in a discretionary investment mandate? That, I mean, people who know what they're talking about in the context of DFSA rules and so on may have one idea what it is, but what does it mean simply when he says will be invested on your behalf under discretionary investment mandate? I mean, on the face of it, you know, you would have expected all the right forms to be filled in to comply with the FSA regulations and all the rest of it. There'd be lots of, you know, the usual know your client stuff and all this sort of thing with which we're fairly familiar. But whether or not Mr. Prasad or Mr. Al-Gharqawi had any expectation of that, I don't know.
And we have no evidence in that regard, Your Honour.
No. I mean, this is a bizarre case, Mr. Patrick Joyce, because there is an absence of evidence from what I would call the two main protagonists, namely your client on the one hand and Mr. Al-Gharqawi on the other.
And in my submission, the absence of evidence from Mr. Al-Gharqawi is infinitely more troubling. For all of the reasons that we have covered, and the additional reasons that we don't know what he meant or what he understood by discretionary investment mandate, we don't know what the discussions were. We have absolutely no evidence at all in that regard, and the burden of proof must rest with the claimant, whether the claimant is properly Muzoon or Mr. Al-Gharqawi. But
well, I understand the burden of proof point, certainly.
Yeah. And to spell out fraudulent intent objectively established on the basis of what we are reading here is, in my submission, simply impossible. You cannot spell out fraudulent intent from this. And there's a further point, which is the chronology. The claimant pleads that at all material times from its establishment in 2002 until 2018, Abraj Group was a very well-respected, substantial private equity house, and that it was only in 2018 that the true situation became apparent. So how does the claimant establish on the face of this letter anything untoward back in October 2015, even on a general basis. And of course, as has already been pointed out in the course of the submissions that my learned friend was addressing to the court and the court's response to those submissions, it's not sufficient to point to generality. It has to be with regard to this defendant at this point, with regard to this investment and this letter. And in our submission, it simply takes the claimant, whoever the right claimant is, nowhere.
Yes.
Your Honour, we then get on to a chain of emails, which was the phrase my learned friend used. It's only a very short chain. That is after, of course, the receipt of the first tranche of funds. So none of that can have any relevance to the investment of the first tranche. And insofar as the emails are derived from exhibits to the Deloitte report, rather than emails which were in the immediate possession of Mr. Al-Ghagawi or Mr. Prasad as the natural person behind Muzoon, insofar as emails are derived from exhibits to the Deloitte report, we say that that's inadmissible, but I will come back to that. If one goes...
But I am entitled to look at those for any inference that could be drawn as to intention, subject to the dating point, which I fully take on board.
Well, with respect, I would not go so far as that, because those emails have been produced as an exhibit to a report. They are not emails which are within the possession, custody or control of Mr. Prasad. They are not emails in the custody, possession or control of Mr. Al-Ghagawi, and they have not been properly produced or adduced in evidence.
Well, that's the admissibility point, but you'll come back to that. But
I will come back to that.
Let's just assume, for current purposes, I'm against you on that. Assume that, just for the purpose of argument. I'm entitled to take what I can out of them if I can make proper inferences as to the intentions of Mr. Naqvi. I'm entitled to do that, aren't I?
Well, Your Honour, in our submission, must look at the circumstances in which those emails have come about.
Yes.
And they have come about from the records of the liquidators. We haven't been given any disclosure in relation to that. We haven't been able to cross-examine any of the makers of the Deloitte report, and therefore the people who have produced the documents and the emails that Your Honour wishes to have regard to. And when one looks at those emails, there are massive gaps in time, there are redactions, and it is simply, therefore, in our submission, wholly unclear as to whether that is indeed a proper email record, or whether it is an extraction, because in some instances there are months gap between the emails that have been produced as an exhibit to the Deloitte report. Really unexplained gaps of periods of time, Your Honour, if Your Honour looks at the dates carefully. And the redactions make it absolutely clear in our submission that someone has gone through and expressly edited, if only in terms of redaction, but we say it can't be discounted that there's been further editing, that we haven't got a complete picture. And if we haven't got a complete picture, the picture is also compounded, a point which I was going to come on to, but I'll make now. If one has regard to the rules of the DIFC courts, part 29.102, that requires service of notice of intention to rely on hearsay evidence. All of this is plainly hearsay evidence, Your Honour. The report itself is hearsay evidence. The exhibits to the report are, if you like, double hearsay evidence, because...
Well, except that they are, by whatever means you obtain them, they are nobody's denying the authenticity of the documents themselves.
No, there's no challenge to the authenticity of those documents.
Can I just ask you
but
this?
there is a challenge to the completeness of the record of those documents.
I understand that. Can I just ask you this, that two questions that arise in relation to the comprehensiveness of the documents, or what could be missing? The first is, we've had disclosure in this case, right?
Mm-hmm.
And on what basis did that disclosure take place? From the claimant I'm talking about in particular.
The claimant has expressly said that they have no further documentation.
Yes.
And this, what we're looking at now, of course, is one of the exhibits to Mr. Prasad's first witness statement. Sorry, we've moved on, I suppose, to the Deloitte report. The Deloitte report
my understanding
is an exhibit to a subsequent...
I'm so sorry to keep interrupting, but can you confirm my understanding? The documents that were originally attached to Prasad's statement, do those represent the totality of what was in the claimant's hands for the purpose of disclosure? And is it right, therefore, that all the material that is produced by Deloitte's, which was not attached to that statement, is simply that which has been produced by Deloitte and wasn't in the control of the claimant?
I think that's right, and I think I can make that good. I don't, I'm afraid, have the exact page reference to the bundle, but it's my clear recollection when I read the claimant's disclosure statement that they confirmed that there was no other document within their possession, custody, or control which should properly be disclosed. So they are on that basis, they would be in no better position to know the comprehensive nature of the material provided by Deloitte than anyone else. And that's the real problem, because it is for the claimants to adduce admissible evidence in support of their case. And that's exactly
Mr. Naqvi has disclosed everything that he personally has, has he?
Yes, I'm sure, again, one can look at the basis on which the disclosure statement was made. It's towards the end of the original bundle, so I can find that and provide a note for it. But of course, Mr. Naqvi has not had any access to any documentation since, I believe, August, or since I think I'm right in submitting, August 2018. When the liquidators were appointed to the various relevant abroad entities, companies. So he would have no access at all subsequent to August 2018 to any of the company documents.
Did the DFSA reports exhibit a whole lot of documents or not?
I only have what has been produced and provided, and that again is exhibited, I think I'm right in saying, to Prasad 3. Right. We've got that's all we have. If there were further material, then one would have expected it to have been disclosed. And indeed, one certainly cannot discount the existence of further material, because again, it's covered in the written submissions, Your Honour. But if one looks at the opening pages of the Deloitte report, it specifically refers to what appears to have been a letter of instruction. That letter hasn't been disclosed. That letter plainly had at least 5 appendices, because the existence of 5 appendices is disclosed again on the opening substantive page of the Deloitte report. We haven't seen that. And the Deloitte report expressly makes reference to an earlier report, which appears to have been furnished to the claimants, dated the 7th of October 2021, I assume, because this is a November 21 document. We haven't seen that. So it's riddled with holes and gaps, not speculative holes and gaps, actual holes and gaps which can be pointed to.
Yes.
Your Honour, we can then go back. That was in relation to the emails exhibited to the Deloitte report. If one looks at page, I think it's 2582. Let me just see if that's right. No, it's 2583, my apologies. This was one of the documents that my learned friend relies upon, and he places great store by, and of course, yes, I'll come back to the timing point in due course. He places great store on the word synthetically or synthetic, which he says means artificial or and therefore to be equated with fraudulent. Your Honour, we have looked at this email and Your Honour has read this and Your Honour has put points to my learned friend. In our submission, in the context of this email, and despite the judicial invitation to go through it line by line, the learned friend has not grappled with what synthetically means in this context. It does not mean fraudulent holding. What it in our submission plainly means is that it was a book transfer without an actual transfer. And that's what it means. For other investments, we can look at AH positions and either transfer against cash or synthetically hold the underlying investments. When one looks at the either or, transfer against cash equals actual transfer for cash value. Synthetic holding must and can only mean a book transfer. So it achieves the same end. It's just that it's a slightly different way of achieving that end. There's nothing untoward in the word synthetically. It certainly is not fraudulent. And then my learned friend took the court through the further emails in September 2016. I think that's page 2545. Oh, no, it isn't. I have a misreference. I apologize. The 2nd of September. Oh, has my video frozen?
You've been frozen for a very long time, Mr. Patrick Joyce, but I can hear you perfectly well.
Oh, but can you see me moving now?
No.
Oh.
You're utterly static.
Oh, I apologise, but have any of my submissions not been heard?
No, I've heard all your submissions perfectly well.
I apologise for the interjection, but my clerk has just put his head around the door saying that I've frozen. And it was therefore important that I worked out whether I was frozen in terms of picture or also in terms of sound. I'm happy to continue if that's convenient.
Yes, you've been frozen since you began your submission, so far as I'm concerned.
I apologise.
That's all right. I can't tell the expressions on your face, which are sometimes revealing for an advocate, but more often of no help at all.
Well, Your Honour, may I try to just take 2 minutes to sort out the technical glitch? I'm relieved that my submissions have been heard, but I would like to be able to see and be seen. May I spend 2 minutes just to sort it out?
You may. As an advocate, I always used to regard it as more important to see the judge's expressions, to see whether or not he was laughing or crying at my submissions.
Well, that's true. And I did think that I was able to see you and my own friend in a sort of half
Yes.
screen. May I just take 2 minutes and then
Yes, of course.
I can resume. Thank you so much. Leave that. And I was thinking I should rejoin. Ah, well, it is moving. Your Honour, is that better?
Well, I wouldn't like to say better, but you're mobile.
Right. Yes.
You're moving. Yes, that's
I'm
fine.
moving.
And I can see you laughing too, which is always a good sign.
Well, in that case, all communication, both oral and visual, is restored, and I do apologise for having to take a little bit of time out just to sort that. I was also.
I took the advantage of the moment to look up the word synthetic.
Yes.
And in the context of synthetic shares, I don't know which definition where I got it from, but on Google, if you go, it says financial assets used to create the same payoff pattern as investing in the underlying stock. And one usually, I've normally come across the expression in the context of derivatives, which are often referred to as synthetic instruments and so on. So it, as you say, it doesn't necessarily mean artificial, but it's a different way of creating the same substance. That's what synthetic, I think, means in the context usually of financial instruments, but which of course does tie in with the suggestion that they were going to allocate in some way.
Yes.
In their books, and therefore this is the question I wanted to ask you, because I think this is really the way in which the point has been put by the claimants, is saying the essence of what was being said was that they would actually receive stock units in a fund, and reliance was placed on the corporate organization and the separate funds in which the average companies acted as the general partner, and stock units were issued, some of which were held by the general partner and some presumably by other limited partnership partners who may well have been other average companies or indeed individuals or other investors. I don't know.
Well, Your Honour, yes, I heard that interchange, of course, between the court and my learned friend. And what my learned friend is seeking to do is to give a very specific meaning to the words discretionary investment mandate. And he has sought to do that by reference to a number of the paragraphs in the DFSA Code of Conduct and Collective Investment Law. None of that has been pleaded. Those were again documents which were provided only yesterday. But, and I can look at them in particular detail, going through each paragraph. I did that in the short adjournment between learned friend closing and my starting my submissions. But when one looks at that, all that talks about is separating and out essentially the firm's day-to-day account, the working account or the administrative account for any financial concern. Because obviously it's general, but here we're talking about AIML in the DIFC context. So it's separating out the firm's account from one or more client accounts. And indeed, when one looks at the paragraphs that my learned friend referred to, I think in one instance it talks in terms of one or more client accounts. If that's right, I can make it good by the precise reference. If it's not, I don't think it detracts from the point. It's no different from a firm of solicitors, which will have an administrative account for paying the milk and whatever, but will have one or more client accounts into which it receives funds for the purpose of holding client monies in a solicitor's case, or making investments in a private equity case. Of course, if one is talking, and there's no evidence at all in our submission that there were copious individual client accounts in the name of each individual client of any and all of the Abraj companies or entities that one's seen on the organizational structure. That would be a gargantuan exercise in holding separate accounts. All that one's talking about is that it should be separated from the milk account. And that in our submission is where reference to the DFSA Code of Conduct and the Collective Investment Law leads one. Not only is it not pleaded, but it's not a good point. So going back to the point that Your Honour raised, that my learned friend's submission is that monies would be received into stock units. Well, with respect, no. All it was a discretionary investment mandate. And I hope that answers both Your Honour's point raised in the round and takes the court back to the evidence that my learned friend places in support of his precise case on that aspect. So, Your Honour, when one looks at the further emails which occurred between the first tranche and the second tranche, Your Honour put to my learned friend that really the only email that he could rely on was the 2nd of September 2016 email. And I cannot work out why I couldn't see that. Let me see. I think it's, there we go, that's it. Yes, sorry, it's 2546, not 2545, my error. If one looks at 2546, that is not an email from Mr. Naqvi at all. It's an email from Mr. Lakhani, and simply says what Mr. Lakhani understands to be the position. My learned friend said, well, of course, Mr. Naqvi was privy to all of this, and he was copied in on emails. Your Honour, he was not. This was an email from Mr. Lakhani to Mr. Prasad, and the only person who was copied was Mr. Narayanan Rajagopalan, not Mr. Naqvi. So in my submission, my learned friend's case crumbles in the light of that circumstance. And then one goes on, for the sake of completeness, to the email of the 26th of January, which is to be found on page 2550, and the email of the 16th of March, which is at the head of that page. But reading it in chronological sequence, the first email is again addressed from Mr. Prasad, not to Mr. Naqvi, but to Mr. Lakhani, not copied by Mr. Prasad to Mr. Naqvi, but copied to Mr. Narayan Rajagopalan, and simply says, could you provide us with an update on the investment portfolio? The response, which my learned friend prays in aid, is, as I say, at the top of that page, this time not even copied to Mr. Narayanan Rajagopalan, simply says, as far as Mr. Lakhani is concerned, subsequent to the below valuation update, the allocation of investment has increased by 300,000, drawdown, etc. Total investment allocated to you for Karim is 1.8 million, and the investment is valued at 4.46 million. And that is the sum total of the email correspondence that my learned friend then goes on to say induced the claimant to make the investment of the 17th of May 2017. That was an inducing on the claimant's case, which took 2 months to work through. And what happened, as Your Honour is perfectly well aware, a transfer was made, a cheque in this instance, was made and drawn by Mr. Al-Ghagawi on Mr. Al-Ghagawi's account. How did the exchange of emails that we've seen move from Mr. Prasad to Mr. Al-Ghagawi? What conversations took place? On what basis did Mr. Al-Ghagawi draw his cheque? Was there any business accounting within the books of Muzoon in 2017 in the way exactly identical to the way that should have taken place in 2015? In our submission, this is hopeless in terms of the time lapse between the last email correspondence that's relied upon and the action taken by Mr. Ghagawi. It's hopeless because this email correspondence did not emanate from Mr. Naqvi and was not even copied into him. And it's hopeless because there's no knowledge and evidence before the court as to how this email was passed on from Mr. Prasad to Mr. Al-Ghagawi in order for Mr. Al-Ghagawi to write the cheque, which he evidently did. That is really the sum total of where we stand, other than the covering letter for the investment, which is at page 2552. And this is a letter from Mr. Prasad, but clearly enclosing check number 1025, and check number 1025 is to be found at page 2553, and that is plainly drawn on Muhammad Abdullah Al-Gagawi account Labour Camp 2. One can see who drew that check. And on the 17th of May, Mr. Prasad wrote to Mr. Rafiq Lakhani as follows: subject, investment, His Excellency Muhammad Abdullah Ali Al-Gagawi. Even Mr. Prasad is representing that it's a personal investment on the part of Mr. Al-Gagawi. It's not subject investment Muzoon Holdings. Then it goes on, upon instructions from His Excellency Muhammad Abdullah Ali Al-Gagawi, personal instructions provided by the natural person. Please find enclosed a check for 10 million dirham towards additional investment under the discretionary investment mandate. He has with Abraj. He has with Abraj. We request you to kindly acknowledge the receipt of the check and sign and return us a copy of this letter. Your Honour, when one stands back and looks at the totality of the material relied upon by the claimant in support of some sort of fraudulent representation being operative and inducing the payment of the second tranche, it simply is not there. And whether one looks at it from the claimant's perspective, no evidence from Mr. Gagawi, no evidence other than that which we've seen and just looked at from Mr. Prasad, or whether one looks at it from the defendant's perspective, absolutely no emails concerning Mr. Naqvi personally at all. However one cuts it, you come in our submission to the same conclusion. My learned friend then went on to say, to address the court in relation to loss. And he said, well, we've paid, or payment was made of 20 million dirham. And that means that we've suffered loss. It's plain that we've suffered loss as a result of the deceitful acts. We've looked at the deceitful acts, but with respect, the learned friend's case doesn't begin to grapple with what the claimant must prove, because it's well known that investments can go up, investments can go down as well as up. And from a learned friend to say that he has established his loss, in our submission, he plainly hasn't. The next point in time was the
That's
DFS.
a different point, isn't it? Because the loss that's claimed is simply the sum of money that was sent. Because it's put on the basis that but for the wrongdoing, he wouldn't have had the money. He's not claiming the loss from the investment.
Well, it's unclear.
Saying this is the sum of money that I gave you and I haven't got it back.
Yes, but his case is that monies that he gave for investment purposes weren't invested, and
Yes.
he wants it back. But if you give it to someone for investment purposes, then what would have happened had the instructions been carried out in terms of investment and return? We just don't know. We don't know whether Kareem was a good investment or not. We know that some monies came out of Kareem and went into something else called modest or modest. That's part of the claimant's pleaded case. So there were all sorts of entries and contra entries and payments out to the claimant, certainly in relation to modest. We've heard nothing at all about that. So how on earth, let me put it in more temperate terms. How can the claimant begin to prove its case on loss when one knows that monies were paid in, monies were paid out, monies were applied to other investments. There's a reference not only to Mr. Al-Gagawi's investment, but also Ms. Al-Mari's investment. Again, I can provide you with the page reference should the court wish so in due course. There is no basis for establishing any loss on the evidence that the claimant has put forward. When I then come to the Deloitte report, and with regard to that, I begin with Your Honour's comment that the makers of the report had not been called, and that in my submission is not only a fundamental flaw, it is an insuperable problem in the way of the claimant's case. And it's an insuperable problem because the report hasn't been properly adduced. The makers of the report have not been available for cross-examination. And I should perhaps just look at the report, and it's to be found.
Well, it's all the stuff on the front page you rely on, isn't it?
Yes, it is, and I was just going to provide Your Honour with a page reference. I've got it in hard copy form, which will probably, I hope I can turn up quite quickly.
Well, it's somewhere around 2570, a bit earlier, perhaps.
Yes, it's 2566 and 2567. I think if we look at 2566. Yes, and Your Honour is absolutely right. It's the first and second pages of the report. Your Honour has seen the disclaimer and expressed no surprise at that, but of course the effect of the disclaimer is substantial in relation to the reliance that one could place on this report, even if it had been properly adduced. But then one comes to the introduction, which is the page 2567. The first paragraph on page 2567 it deals with the point, the letter of instruction point that I've already addressed you on. The second paragraph refers to the appendices and makes clear that there were a number of appendices, I think totaling at least 5, but it's undisclosed. No, we can see the number of appendices subsequently. In the second paragraph of this document, the number of appendices is undisclosed. The third paragraph simply says that they've run keyword searches. We don't know what the keyword searches were, and have provided the conclusion set out and a chronology. And then the final paragraph of the introduction, the report supersedes our prior report, not disclosed. And then the source of my information about there being at least 5 appendices is if one looks at the foot of page 2567, going over to page 2568, there are itemized the 5 appendices which were attached to the letter of the 3rd of August 2021. In our submission, it's completely impossible to rely on this report in these circumstances. It's incomplete insofar as the letter of instructions haven't been provided. The makers of the report haven't been called, and when one looks at the material which my learned friend took the court to, on its face, and it was a point which was raised by the court, why has it been redacted? Who has redacted it? The redaction was provided by Deloitte. And Your Honour, the emails which I've referred to begin at page 2576.
Yeah.
There one sees the redactions. One can see the gaps in terms of timing, particularly if one, for example, goes on to 2577. There's an email of June the 27th, 2016, then July. Then, in fact, if one goes back up the page, oh no, I think it's just a duplication of emails. Yes, my apologies there. But no, if one goes down to the page, to the email at the bottom of no, the next point I would take the court to is the top of page 2579, a very big redaction. And if one goes on to 2581,
But one assumes that was a separate email at the top of.
yes, a separate email as to which we are completely in the dark. And then if one looks at 2581, an email which I think we have looked at, this is an internal email. Dear Mustafa, as you're aware, we have to provide valuation of their portfolio by the end of this week. We've decided on giving them Kareem 1 million and blank 1 million. Why has that been redacted? It may be another entity, and maybe an entity other than Kareem, but this is on its face an allocation to the claimant, be that Muzoon or Al-Gagawi, and yet it's been redacted. That's something which the claimant could plainly have enlightened us upon, but hasn't. So in our submission, the court, I know you didn't put it quite in these terms in putting points to my learned friend, but there was a hint that the emails attached to the Deloitte report may have a standalone existence separate and distinct from the email report, and may carry greater weight or indeed admissibility with the court than the report itself. In our submission, that simply can't be right, because the material which is exhibited to the report depends on the report. And if the report is inadmissible, then everything which is attached to and therefore secondary to the report must also be inadmissible. And when one investigates the emails in substantial detail, as we've just done, there are real problems with admitting these emails, even if they were otherwise admissible. So far as the cases are concerned, my learned friend says that Sims, he attempts to distinguish Sims. In our submission, that doesn't dent our case on that case at all. So far as Tawaragantse and the local authority against M is concerned, echoing the point that you learned that Your Honour has made, if one looks at Tawaragantse, it certainly seems to be about admissibility in the context of the tribunal and not in court. Certainly Sims does not seem to have been referred to, and Sims is of course a Court of Appeal authority. The case of Tawaragantse is a decision of Mr. Justice Moylan, sitting, as he then was, sitting in the administrative court. So a court of first instance.
It's Justice Mostyn, I think.
No, sorry, Mr. Justice Mostyn, not Moylan, Mr. Justice Mostyn, but sitting at first instance in the administrative court. Sims, of course, is a court of appeal case. So in our submission, either the well, on one basis, Tauragakse takes the learned friend nowhere because it's addressed at a different point. If it is addressed at the same point, it's per incuriam with Sims, or it's to be confined to its own particular facts. And when one looks at Sims, as I've sought to do in the references provided in our skeleton, it's quite clear that Hollington, Hollington and Hewthorne, for all the challenges that it has sustained over the years, is still good law. And now is of some considerable longevity. And we have, in any event, the more recent analysis in Sims. So far as, just going on to page 2600, my learned friend took the court to the head of this page with regard to the decision notice of in relation to Mr. Naqvi in person.
I'm sorry, Mr. Joyce, I lost the plot because I was taking a note. Where are we now?
I invited the court to go to page 2600, 2600.
Thank you. Yeah.
Sorry, I didn't deal with a local authority in M, but that local authority in M is, of course, a first instance family division case, and the circumstance of admissibility of evidence in the family division is very different when one's dealing with children and family matters than it is in a commercial environment. So again, albeit that I don't think we have particular paragraph numbers which my learned friend relies upon, I would deal with that case on that basis. And whilst I'm talking about it, I would also deal with the case of Richardson and Rohan on that basis. My learned friend has provided no paragraph numbers for me to respond to. But going back to...
I think it's just arrived by email, probably.
Well...
I'm just having a quick look. That was just been sent to me.
I hope it won't be discourteous if I don't immediately break in and look at the email.
No, I'm just seeing it. Yes, that's what it is, I think. Yeah.
Well, I may come back to that, but with the court's leave, I'll continue with my submissions. When one looks at the head of page 2600, this is the entitlement to the Naqvi decision notice, and it is absolutely correct in what it says, that it has been referred to the Financial Markets Tribunal, where the parties will present their respective cases. Any findings in this decision notice are therefore provisional and reflect the DFSA's belief as to what occurred and how it considers the conduct should be characterised. The FMT will determine what, if any, is the appropriate action for the DFSA to take and remit the matter to the DFSA with such directions as the FMT considers appropriate to give effect to its determination. The FMT's decision will be made public in due course on the FMT section of the DFSA website. And mindful of that, I have confirmed just this morning to make sure that it was absolutely the right case. That the first instance decision, the DFSA decision notice that we have here, remains under challenge to the FMT in the DIFC. One therefore has an extraordinary situation where my learned friend seeks to elevate that which is expressly provisional, in addition to the fact that it hasn't been properly adduced and therefore isn't admissible on that ground. He seeks to elevate that which is expressly provisional to a document which is proof of the content, proof of the truth of its content. It plainly is not. there is again no evidence. So far as all of these points are concerned, there is no notice of hearsay. I've already referred the court to the requirements of RDC Part 29.102. And the challenge to the Deloitte report is more on a basis of three rivers, as we made clear in our written argument, rather than anything else. And my learned friend seeks to, again, distinguish the Deloitte report on the basis that, quotes, it's not a third-party document such as the Bingham report. I simply don't understand the basis on which my learned friend seeks to draw a differentiation between the Bingham report and the Deloitte report. They are both plainly third-party reports, and therefore what my learned friend is seeking to do now is, in our submission, on all fours with what occurred in the Three Rivers case, and it is inadmissible. Your Honour, those are my responses. I hope dealing with all of the relevant points raised by my learned friend. Before I turn to my skeleton, just to briefly review that, on a pleading point, again, it's flagged up. But my learned friend, in his amended claim form, put his case on the basis of a constructive trust. Well, that has not been pursued in pleaded form nor in submissions. And given that the monies were plainly paid to Abraj Investment Management Limited, AIML, look at the check, look at the transfer, yeah, it is difficult.
I don't need you to address me on that, but if and insofar as it is pursued, there would be room for knowing assistance in a breach of fiduciary duty, as opposed to actually a breach of fiduciary duty as such, if it can be shown that what actually happened was all that the direction of Mr. Naqvi.
First, Your Honour is absolutely right, and Your Honour has, I think, taken up a point which is self-evident and made in the written submissions, namely that my learned friend's analysis of the SPL private finance case doesn't demonstrate that there's a cause of action in dishonest assistance on the part of the investment manager. It was dishonest assistance on the part of the director who was in question. One then has to lay the groundwork in pleaded form and in evidential form for a case on dishonest assistance. And if you're going to do that, you have to raise it as a cause of action in the claim form. You have to plead your case in the statement of claim. And of course, my learned friend had a full opportunity to amend as he saw fit. The only amendment was in relation to the quantum. And there is no basis for a dishonest assistance claim. And of course, dishonest assistance is an ancillary claim or a subordinate or a consequential claim, in that one must establish the fiduciary duties owed between the investment manager and the claimant, and then go on to plead the dishonest assistance in relation to the breach of the fiduciary duty between the investment manager and the claimant. And in our submission, that's absolutely clear from several of the cases, not least FM Capital Partners and Marino. But
it's blindingly obvious, Mr. Patrick Joyce, that an investment manager has a fiduciary duty to the investor, isn't it?
AIML has a duty, yes.
Yeah.
Yes, but where is that pleaded, Your Honour?
Well,
it's and that is, with respect, the problem.
well, it isn't, isn't it? Because the way the point is put, in fact, is not dishonest assistance, but as inducing or procuring a breach of a legal right within the terms of Article 32, which is a different way of putting the same point, but within the context of DIFC law. So that is pleaded, and that is something you have to deal with.
With respect, Your Honour, it needs to be pleaded. It isn't pleaded, because if one's going to put a case on inducing a breach of contract, then
it's not producing a breach of contract. It's procuring a breach of a legal right. It's specifically Article 32, which I had a quick look at.
Procuring a breach of a legal right, but then one must plead the legal right, and then one must plead with appropriate and full particularity how that legal right, how the breach of that legal right was procured. And goes back to really the same point, albeit different language. And let me just get Article 32 in front of me. It needs to be pleaded. Your Honour may say, well, it's obvious, but it still needs to be pleaded. Who owed what legal obligation to the claimant? It hasn't been pleaded, and Your Honour may say, well, that's a smart point or a cute point. If that were all, it isn't a smart point or a cute point, because a claimant must plead their case properly. But then one passes on to B. He, that is Mr. Naqvi in this instance, intentionally induced the third party to breach that obligation. When did he breach? When did he induce it? How did he induce it? What was said to whom? Who was the person to whom it was said, and how did it operate on that person's behaviour and mind? And what was the intention of Mr. Naqvi in relation to whatever he's supposed to have done? If it isn't particularised, we can't answer it. And it isn't particularised because it didn't happen. And then the claimant suffers loss as a result of the breach. Well, one has to, again, identify what the breach is with clarity in order to pass on to loss. So whether one looks at it in terms of dishonest assistance or inducing or procuring a breach of a legal right, in my submission, the claimant meets a brick wall with slightly different wording, but it's essentially the same brick wall. They've not pleaded the legal obligation. They've not laid any groundwork for intentionally inducing a breach, and therefore loss as a result of the breach cannot be established.
Well, what about the commingling of funds? If for the moment, for the purpose of this argument, I'm entitled to find that, as Deloitte say, that all the monies that were ever obtained were commingled.
Well, the answer to that in my submission follows from the submissions that I've made in relation to the effect of the Code of Conduct and the collective investment regulations. If one looks at those, maybe we should look at those. Let me just.
Well, there are 2 points that arise there. One is, and I can't remember what the law now says about breaches of the rules constituting a civil liability as well as a regulatory offence. There is some law on it. I can't remember quite what it is in the DIFC. There are two cases. It's the Saracen case, isn't it? And I can't remember the other one.
Yes, there is a.
I think I decided one myself, but I can't quite remember.
Yes. I don't know. No. And of course, there are so many Saracen judgments that it's going to be a challenge to find the right one. But yes, if one goes to supplementary bundle, the supplementary bundle of authorities that Malone and Friends submitted yesterday,
Yes.
and turns to page 6. And it's paragraph A 5.3.1 on page 6. Where an authorised firm, sorry, does Your Honour have it?
No. Give me the page again.
It's page 6 of a bundle which was provided, certainly as far as I was concerned, yesterday.
Let's
And
try.
I think it may be separate from the.
Well, I've got a bundle of claimants' additional authorities here.
Yes,
in
yes.
the DFSA Conduct of Business Module
That's
COB Rule Book.
That's it.
So which
Yes.
paragraph are we looking at?
If one looks at page 6 internally of this bundle.
And what's the rule?
Sorry, I should perhaps take the court to page 5 so the court knows what this document is. Page 5 is entitled the DFSA Rulebook Code of Business Module. So it's the COB regulations.
Yeah.
Then at paragraph A 5.3.1, which is the following page, page 6.
Yes, I'm with you.
And it's the highlighted paragraph. Where an authorised firm holds or controls client money, it must ensure, except where otherwise provided in section A 5.5, that the client money is paid into one or more client accounts within 1 day of receipt. So that, in my submission, there's no indication that there's a relevant other provision in this. That indicates what is meant by client account. It's to separate and differentiate, just as solicitors do, between the firm account and the client account. Now, monies are commingled in a client account, unless, as I say, you have the gargantuan exercise, which would happen many thousands of times a day, potentially, of setting up a separate account for each separate client.
Yeah.
That's at the heart of Malone and Friends submissions in this regard, and it's to, in my respectful submission, to overlook what is really meant by a client account.
Well, I understand that.
So there's going to be commingling.
Well, there's going to be commingling between one client's money and another, with simply internal book entries that tell you how much each client has. Yeah. As in the solicitor's client account, no doubt.
Yeah.
But in terms of using the money for other purposes, there's some indication, isn't there, in the Deloitte report that I can't remember now where it is, but perhaps someone's going to have to take me to it, that the money was used to pay staff salaries and goodness knows what.
Some monies let's assume that some monies were used for that purpose. But those monies would be paid out of profits, and profits are derived from the good investment of monies invested on a client behalf. So and therefore there would be a payment out of excess profits from the client account to the firm's account, because as long as the client account has all of the monies to satisfy any drawings that any client may make, that which is over, that which exceeds that amount, is the firm's trading profit. So to say, this client's monies were used for other purposes, it can't possibly be shown that. We would have to look at, the claimant would have to adduce evidence that the monies, which on the basis that we're now working on, the hypothesis that they were commingled, that what was paid out in terms of salaries and other matters was the claimant's monies as opposed to anyone else's monies. And once it's been commingled, you can't do that.
I think it's page 25, could be 2570, but it's the part of the Deloitte report. This is what I had in mind.
Yes, let me get
I got the right. No, that's not the right page number. Yes, it is. At the bottom, 20th May 2017. AMIL bank account receives $2.7 million from Gagawi, which is commingled with other funds. Okay, take the point that may mean client funds, but other expenses are immediately paid from this bank account. AMIL records a debit of 2.7.2 blah 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 to cash and a corresponding credit to employee payables. The journal description is funds received from Mohammed Abdullah Ali Al Gawar. So if I'm entitled to look at this.
Sorry, I wonder if I could just ask Your Honour to repeat the page reference.
I'm so sorry. It's
my fault. I didn't.
No, I think it's 2570.
2570. Yes, I have it.
And it's the entry at the bottom, which on the face of it appears to me to say that the second tranche, when paid, went straight to pay employee salary.
Well, am
I misreading that?
Well, with respect, I don't think that follows, because the monies were received and presumably would go into client account. So the $2.7 million received and commingled. Other expenses are immediately paid from this AIML bank account. Yeah. But you've got, let's assume that there's 50 million in the account into which the 2.7 million is received, leaving 52.7 million. And let's assume that the other expenses are 10 million. So 10 million comes out of the client account, which holds 52.7 million. It's commingled funds. Whose monies have been paid out for those other expenses? It can't possibly be said to be the claimant's monies.
Well, I suppose that depends how you read the journal description is.
And we don't have disclosure. We don't have a disclosure of the journal description. Yeah,
the question I think is this: does the journal description that's referred to simply refer to the receipt, or is it a reference to the credit to employees payable?
But on its face,
do you see what I mean?
I do see what you mean. What you mean, but if I may put it this way, Your Honour, I think Your Honour is straining every sinew to help the claimant's case, because what it says.
I am sympathetic towards it, Mr. Patrick Joyce, for very obvious reasons.
Yes, I accept the point that you made at the outset of submissions, Your Honour. But the reason why I put it in those terms is because of the first two words of the journal description: funds received. It's only talking about receipt. So that's the first point on the face of what we've got here. The second point is, well, where's the journal?
Well, I understand that, but the oddity about it is exactly that same figure that goes in and out.
Yes, but once it's commingled, even if it is the same figure, it doesn't retain an integral identity in the client account. That in my submission is the point. So, Your Honour, those are the points that I would respond to by way of the oral submission of the learned friend. I know that Your Honour's had an opportunity to read both skeleton arguments, and I'm not too sure the extent to which Your Honour would wish me to go through my written submissions laboriously. But Your Honour will see from paragraph 2 that we make good our bold statement in paragraph 1 that the claimant's case is flawed fatally for several reasons. Wrong claimant, no claim, wrong defendant, no admissible evidence. For reasons which I think are sensible, we've chosen to address the no admissible evidence point first. Your Honour, of course, has the introductory matters with regard to the parties, paragraphs 5 and 6, other introductory matters with regards to the pleading of the case by my learned friend, paragraphs 7 to 10. We do also deal with the statement of reply for completeness subsequently. In relation to no admissible evidence, there are 5 categories set out in paragraph 11 in my submission for the reasons which are explained quite extensively and which are drawn to their conclusion. Where do I refer to the 5 categories? Maybe I should take. I come back to the 5 categories and say that none of them are admissible, but I take them point by point. Paragraph 12 through to 17 deals with the DFSA decision notices. The judgment of Sims and the passages that I rely on are clearly set out in paragraph 16. I'm happy to take the court to those paragraphs if the court would wish, but otherwise, in my submission, they make good everything that we submit in paragraphs 12 to 17. Then we turn to the Deloitte report, and the application of Three Rivers at number 3 at paragraph 18 and deal with that through essentially to paragraph 22. I anticipate that I won't need to trouble the court too much with complaints and amended complaints, cease and desist proceedings and applications relevant to discovery from another jurisdiction, nor with the book, whether it's a work of scholarship or written in an investigative journalistic style. Yes, and then at paragraph 25, this was the paragraph that I was seeking to take the court to, having looked at each of the 5 categories set out in paragraph 11 of the skeleton. We say none of the evidence in categories 1 to 5 above, that's the categories in paragraph 11, is admissible, and claimant is quite incapable of proving its case. Then we go on to dealing with no claim, and again, I know that Your Honour has had an opportunity to read this. I'm just wondering how quickly I can, or perhaps I can just summarise the paragraphs as we go through. Paragraph 26 begins by looking at the amended claim form, sets out the basis on which the claimant puts their case, namely of misappropriation of funds by the claimant. He didn't hold the funds. As we make good in paragraph 27, no admissible evidence that claimant transferred any funds to defendant. No admissible evidence that the defendant misappropriated claimant's funds. No admissible evidence that the defendant was under any obligation to return any invested sums, nor any profit or interest. If, contrary to the defendant's primary case, any of the evidence is said to be admissible, which we say is inadmissible, is admissible, then the defendant reserves the right to make further submissions as are appropriate on that admissible evidence. And just pausing there, Your Honour, my learned friend says, well, the defendant has pleaded by reference to a couple of paragraphs of the Deloitte report. in our submission, this is a fundamental misunderstanding of material which can be prayed in aid to plead a case and material which can be prayed in aid to prove a case. And as Your Honour said in the course of argument addressed by my learned friend, if he had properly proved the Deloitte report, that might, I would have made submissions on it, that might have been another matter. He might have been able to make good his pleaded case by admissible evidence. But you cannot validate and rely on pleadings if you do not call and adduce admissible evidence. And that is the complete answer to my learned friend's point in that regard. Constructive trust, I've dealt with the fact that the claimant did seek permission to amend, but only in relation to quantum. Then we come back to the documents in question, that they're inadmissible. Then we deal with the letter and the emails, that's paragraph 32, which we've looked at. The defendant's extradition is in train and really is nothing in point. The application hasn't been finally determined and is irrelevant. Paragraph 33. We then give references to the exhibit of Mr. Prasad, and again we've had an opportunity to look at all of those. But this is in the context of wrong claimant. Paragraph 36. The court is invited to note that the letter we've seen is addressed to Mr. Gagawi in person. And I accept the point that Your Honour has raised about it also going on to Muzoon Holdings, but that's a family office. The remittance application identifies the sender in November 2015 as Mr. Al Gagawi. It may be helpful just to look at that, 2542.
I don't think we need to go there. I recall
I'm obliged. Then we have the email thread, the attached check. Again, I provided page references to the electronic bundle. Further emails are discussed, and the fact that this is all between Mr. Lakhani, not with Mr. Naqvi, and demonstrates that even Mr. Prasad regarded it as a personal investment of Mr. Al Gagawi. Then paragraph 39, well, it's a summary. Claimant's case does not allege that D received C's monies. He didn't. Claimant's case does not allege that D undertook any personal responsibility for dealing with C's money. He didn't. C's case does not allege that D was personally involved in dealing with C's money. He wasn't. And then we come on to the personal liability. Paragraph 42 deals with the fiduciary duty point and SPL private finance, which we've already addressed. And then we come in the final pages of the written submissions to the wrong claimant, repeating the analysis set out previously. We say it's plain that Muzoon is the wrong claimant. It should have been Mr. Al Gagawi in person. We summarise the reasons for that. And then we say wrong defendant, and really build on the matters that I've already taken the court to, culminating in paragraphs 50 to 52, and then the conclusion, which we say follows inexorably. Your Honour, unless I can, well, I said I would make submissions in three parts: respond to my learned friend, take the court as rapidly as conveniently as I could through my written submissions, and respond to any further questions that the court may have of me.
what I think I would like to do, we were due to take another break when you had completed your submissions, which you've done a little short of the allocated time. As I see it, it's now about just gone 20 past nearly.
Yeah.
Which means I think you're about a quarter of an hour in credit, so to speak.
Yes.
What I'd like to do is take a break now, which will give you a chance to look at the highlighted passages that Mr. Bajamal has relied on,
Yes.
and then you can come back and address me on those, and then we can
Yes.
have a reply from Mr. Bajamal.
Yes, and I will also, Your Honour, take advantage of the break to touch base with those instructing me, because obviously
Yes.
it's more difficult to do it remotely than when there can be a tug on the gown in a courtroom. And
Yes.
if I may, it being lunchtime in England, take advantage to grab a sandwich as well.
Yes, well, that's what I plan to do. Yes, Mr. Bajamal.
Your Honor, yes, if I may make a suggestion on the question of the authorities, I think it's not the fault of the parties because the simultaneous exchange of skeleton made us end up in this scenario where I wasn't able to respond to the points he raised in his skeleton and vice versa. So what I would suggest is that we agree on post-hearing submissions on these authorities, and the question of admissibility can be a short one, which would serve both parties more conveniently.
Well, let's see where we get to. Say there's a break now, which enables both of you to get to grips with those authorities.
Yes.
And at the end of the hearing, we can decide what further we want to do. You've got an opportunity to reply in any event. As I understand it, the plan is we take half an hour now. Mr. Patrick Joyce has a further quarter of an hour if he wants to use it. And then you've got a right to reply for, I think, half an hour, something of that kind.
But it was scheduled for an hour, but I think
whatever it was scheduled for. Yes, I'm not.
I
cutting
think I
it short.
with 45 minutes in any event, so it should be fine.
Fine. Okay. All right. Well, let's work on that basis, which means that we will reconvene at 10 minutes to the hour.
Thank you.
All right. Thank you very much.
Obliged.
Are we all back and ready to go?
Yes, Your Honour.
Very good. Thank you.
Your Honour, I think the only remaining matter was to deal with the references that my learned friend has now kindly provided.
Yes.
And I wonder if by preface to dealing with those matters, I could take the court to Conlon and Sims, which is in the authorities bundle, and it begins at page it begins at page 846, which will be internal numbering 848. Sorry, internal numbering 846, electronic numbering 848, I think.
Of the additional authorities?
No, of the original authorities bundle, Your Honour. I'm sorry, I should have made that clear.
No.
I don't know whether Your Honour has it electronically or in hard copy.
Well, I have it electronically somewhere if I can find it.
Because in my hard copy printout, it's paginated only up to page 100 and then restarts at page 846 for some unknown reason. But if Your Honour has it electronically, it's probably 848 of the electronic attachment.
Odd.
Sorry, does your honour have it? No.
Just bear with me a moment. No. Right, I've got Conlon and Sims. Yeah.
I'm very much obliged, and that should begin on page 846. Just for referencing purposes, I'd take the court first of all to page 875. Paragraph 121 at the foot of page 875.
Yeah.
Given that both David Richards J, as he then was in Sims and Conlon, and Lawrence Collins J, as he then was, concluded that the Hollington case is still good law, and that in consequence the findings of the SDT and of the Divisional Court were inadmissible in evidence. The only issue is whether Mr. Justice David Richards' observations about abuse of process are res judicataris between the parties. So one doesn't need to worry about the remaining issue in Conlon and Sims, but I take the court to what I've just read in relation to the conclusion that the Hollington case is still good law. If one goes on to page 877, one can see paragraph 132 in the Three Rivers case, which is also in the bundle. Lord Justice Jonathan Parker continued in that case, in which their lordships accepted the continued applicability of the Hollington case. And then at 134, the very foot of that page, I respectfully agree with the conclusion of Sir Andrew Morritt VC as to the continuing applicability of the Hollington case. I would then take the court on to page 883.
Yeah.
Paragraph 168, and here we're in the judgment of Lord Justice Moore-Bick. He goes on to say that fourth line in on that paragraph, normally such findings are binding only between the immediate parties to the proceedings and their privies. Indeed, in accordance with what has been known as the rule in Hollington and Hewthorne, the earlier decision is not admissible as evidence of the facts on which it is based. So he plainly accepts the continuing applicability of Hollington and Hewthorne. If one goes on to page 885, and this is the judgment of the third member of the Court of Appeal in Conlon and Sims, Lord Justice Ward, at paragraph 177, acknowledging, and it is acknowledged that the Hollington case, this is just below letter F, the Hollington case has its critics, but is binding on us. The Bairstow case is the way to circumvent the Hollington case, and that too is binding on us. The result of this once, etc. But what it says is that the Hollington case is binding on even the Court of Appeal. So with that benefit, let me turn to the passages. I think I've got them all flagged, where my learned friend has highlighted, additionally beyond the highlights for the that we've already looked at in terms of the COB module rulebook and the legal provisions of the DIFC laws. The first highlight occurs in the case of WA children. This is in the supplementary bundle, Your Honour. WA children begins at page 13, and the passage that my learned friend relies on is paragraph 37, internal page 24.
Paragraph.
Paragraph 37, internal page 24.
Yeah.
And this paragraph simply identifies a number of exceptions to the rule in Hollington Hewthorne. Well, my learned friend doesn't take himself within any of these exceptions, and the rule stands, Court of Appeal authority. If one then goes on to the next highlighted section.
Well, that's quite interesting, though, because that refers to both Richardson Ruin and Zuagansi,
Yes.
and shows that they are special cases.
Absolutely. Yes, I respectfully agree. And Zuagansi, my learned friend has highlighted paragraphs 30 and 31, which is to be found on page 38 of the internal bundle, the internal numbering. The case, the judgment is reported beginning at internal page 29 for the court's reference. But paragraphs 30 and 31, I've already touched on before the short adjournment, or before the second short adjournment. It's exceptional, and we've just seen that in the W&A case. Then the next passage that my learned friend relies upon is in the case of Richardson and Ruin. That begins internal page 52, and my learned friend has highlighted the final few lines of paragraph 12 on page 55. But again, as we've already seen from the WA case, this is an exception. So it's far from, it's not the rule, it's the exception. The next passage that my learned friend relies upon is in the judgment of, this is back to local authority and M and others. Local authority and M and others begins at page 88, and the passage that my learned friend has highlighted is paragraph 28, which is at the foot of page 100, going over to page 101.
Yeah.
Again, it makes it clear that this is wholly exceptional. And then the final reference that my learned friend relies upon is in the judgment of Hoyle and Rogers, beginning on page 112, and at paragraph 51, pages 121 to 122. But that, with respect, doesn't seem to take matters further at all. So in my submission, that disposes of the authorities relied upon my learned friend. That's why I said that it doesn't dent our argument based on the Court of Appeal authority of Conlon and Sims, and indeed the Supreme Court authority, or the House of Lords it was, in Three Rivers and Bank of England number 3. Unless I can assist the court further, those are my submissions, and those submissions in my further submission obviate the need for any post-hearing submissions on this or anything else.
Yes. Mr. Ruin in the family case has a considerable commercial court experience.
I'm sorry, which judge was that, Your Honour?
Oh, a number of us had dealings with Mr. Ruin at one time or another.
Ah, right. I didn't know that he was well known.
well, amongst a particular generation of judges, perhaps. Anyway, there we are. Thank you very much. Those are all your submissions, I take it.
They are, unless I can assist you further, my lord. Your Honour.
Thank you. Thank you. Yes, Mr. Benjamin.
Yes, Your Honour. The first topic I would like to tackle is the capacity issue. With regards to capacity, there's a very important elephant in the room, I have to say. That's the fact that the defendant had not pleaded this defense in its defense, and this is a defense that came about only in the skeleton arguments, and therefore we say that it is for this reason that the court should disregard this line of arguments altogether. In the alternative, if the court is minded to consider this line of defense, I would like to point Your Honour to an important letter, which is at volume 2.4 at page 31.
Yeah. Yeah.
You don't have that.
Yes.
This is a letter from Mr. Gargawi, which was filed at the beginning of these proceedings, and in this letter, Mr. Gargawi personally confirms that the investment was made on behalf of Muzoon, and that Muzoon is the rightful party to bring these proceedings and collect the claim. So in essence, what we say is, again, in addition to the fact that this was not pleaded, and it would be highly prejudicial for the court to allow the defendant to pursue this defense this late stage. However, we say that the only risk that arises out of any of these points is possible double recovery by both Mr. Gargawi and Muzoon, and this letter would serve to prohibit Mr. Gargawi from making such claim in the future. And my instructions are that if that we are also able to provide an undertaking by Mr. Gargawi personally that he will not pursue the same claim against the defendant if the court feels that this is necessary. So that's all I have to say on the point of capacity, unless I can assist Your Honour further on this topic.
You say the point wasn't pleaded. I had missed that.
In the defense, no. Perhaps we should go back and look at the defense, Your Honour.
No. I'll check it through. But if, yeah, okay.
Yes, it's nowhere to be found in the defense. That is that on capacity. I'll come now to address the issue of the Deloitte report, and I have to say that I must insist that we draw a distinction between when discussing the authorities on admissibility. We must draw a distinction between how it applies to the Deloitte report and how it applies to the DFSA decisions, because these are clearly two separate species. With regards to the Deloitte report, I think the only authority that Mr. Joyce relies on is Three Rivers, which relates to the Bingham report. And when we see the skeleton, there's no reliance on anything else other than Three Rivers on this point. And what I would like to explain is as follows. At the moment, the liquidators of Abraj are the legal representative or legal representatives of AIML, because by operation of law, they have assumed all the powers of directors by way of being appointed as liquidators. Therefore, essentially, what has happened in the, again, I use the word report carefully because it is not really a report of any panel of any sort. What has occurred is that the legal representatives of the claimant wrote inquiries by way of correspondence to the legal representatives of AIML, and they responded. Therefore, these statements are simply the correspondence between AIML and the claimant. So therefore we say that there is no need for the court to go into the question of whether Hollington applies or not with regards to the Deloitte report, because simply it is no more than correspondence between parties, which in the same manner that the emails between Muzoon and Mr. Prasad and other representatives.
Mr. Bajmal, I don't wish to interrupt you, but I don't have any problems with the Deloitte material so far as Hollington or anything like that is concerned. My only problem is the Civil Evidence Act problem.
Right, which I, to the best of my knowledge, we do not have an equivalent rule in the RDC rules.
Well, it is the RDC 29, isn't it? That you want to have to look at RDC 29 101, which deals with hearsay evidence.
Correct, but this is in the context when hearsay evidence is being submitted. But in my submission, the Deloitte report is no more than correspondence between parties. In the same manner that the emails between Mr. Prasad and the other members of AIML were admissible. In the same manner, the Deloitte statements should be admissible because they're not acting as an independent body. They're not acting as Deloitte. They're not acting as any professional mandate as such. They are acting as the legal representatives of AIML. So this is AIML providing us with answers to our questions based on their access to the documents.
Yeah.
And therefore, it is not a hearsay evidence, is simple correspondence. So that is my submission on this point. With regards, so I'm glad that Your Honor made the distinction between the position on the DFSA and the Deloitte, and that there's no issue as to there's no doubt as to the non-applicability of Hollington to the Deloitte report. I would like to turn now to address the authorities, and what the highlighted paragraph that Mr. Joyce just took you to basically summarizes a number of exceptions to the Hollington rule, and the just to be clear, we have not advanced any argument to the effect that Hollington is no longer good law. Our position is that throughout the years, so many exceptions were established to the Hollington principle, and that many of these exceptions, at least two of them, we say apply to this case. So what my submission at this point is that in my apologies, Ron. There were two exceptions made. One where the decision is of administrative nature, and again, now we are discussing the DFSA decisions. We're not discussing the Deloitte report. And the second exception was where the decision is of inquisitorial nature, and in Rogers and Hoyle, there was also an exception with regards to opinions of experts, because in that case, this case was about an air crash, and there was a report by the by aircraft investigation tribunal, and then the court did allow the decisions of the panel. In essence, we say that the DFSA decisions are administrative in nature because they are subject to judicial review by the Financial Markets Tribunal, and that is the level where the matters become adjudicatory in nature. Alternatively, we say that the decision of the DFSA is inquisitorial in nature, and on this point, in the opening paragraphs of the DFSA decision, it is described. Perhaps I should take Your Honor to the relevant page.
Yep.
Yeah. One moment, Your Honor. It was 2:06. Yes, it's at 2:560. Is that correct?
2600.
2600.
2600.
2600. My apologies, Your Honor.
Yeah.
If we if we look at paragraph 2 of the decision notice, it says the DFSA served on Mr. Naqvi the procedure. So this section is titled procedure, and then it says the DFSA served on Mr. Naqvi its preliminary notice dated 18th of January 2021, setting out its provisional findings of facts and conclusions. Then it describes the type of the steps that we're taking building up to the publishing of the report, or the work that was done in order to issue the decision. And none of these steps, we say, include an adversarial process as between the DFSA and Mr. Naqvi. That adversarial process would take place at the level of the Financial Markets Tribunal. And the other point is that Mr. Naqvi, the rule in Hollington essentially relates to two limbs. The first limb is with regards to the best evidence rule, that the sitting and presiding judge should always obtain first-hand evidence wherever possible. And then the second limb was with regards to relevance. Because in Hollington, the issue was with regards to a criminal judgment on a road traffic accident and a negligence claim. So the issue there was whether the findings of a criminal judge were relevant for the purposes of assessing whether the defendant had been negligent. We all know that Hollington was later on this point overturned by way of statute, but it continued to be applied with regards to other types of decisions. The conclusion on this is that there is always a determination by some type of a panel in a process where the defendant or the party against whom the proceedings are being instituted makes submissions, and then the effect of that results in a form of, like in the case of Sims, a striking of the roles of solicitors and so on. In this particular instance, there is no such procedure because Mr. Naqvi is not a member of any professional body to begin with, and for that reason we say it should be distinguished from Sims and for the other exceptions. So these are all my submissions on the authorities. There are a few other points that I would like to address, Your Honor, on that came from Mr. Joyce's submissions. Firstly, I would like to just clarify the position with regards to the modest. It was mentioned during his submission, and I would like to clarify that there is no confusion as to what the modest was. Based on Mr. Prasad's witness statement, it's very clear that we are not claiming this amount at the moment. This amount was returned to the claimant, and then it was invested directly by the claimant in the modest, and therefore no question arises as to whether there was, because what Mr. Joyce tries to make out of this is that there were investments back and forth and money flying back and forth between the parties to the extent that there could be some confusion as to what was invested where. But we say that that's simply not the case. There was only one amount of $1 million that was sent back. We acknowledged it. Mr. Prasad provided a witness statement clearly explaining that, and we reduced the claim amount accordingly. Therefore, there's no confusion, and it is, as far as we are concerned, a non-issue. The other point I would like to clarify is with regards to the client's accounts and what client's accounts could mean. What Mr. Joyce attempted to do is to say that there could be multiple client accounts, and that client and client money can be commingled without any violation of any laws. And on this point, I would like to refer to the Code of Business, Article A 5.4, which reads as follows. It's A 5.4.1. A client account, so this is the definition of client account in the Code of Business. A client account in relation to client money is an account which A, is held with a third-party agent, B, is established to hold client's assets, C, is maintained in the name of one domestic firm, authorized firm, or if non-domestic firm, a nominee company controlled by the authorized firm, and D, includes the words client account in its title.
Yeah.
Therefore, for any account to be deemed to be a client account, the title of the account must state that it is a client account, which we have seen the letter of invitation from October 2015 with the account details, and we all saw that the title of the account does not include client account. So the defendants, all of the defendants' submissions on this point simply fail for this reason. These are all the points I wanted to address Your Honor on. If Your Honor have any questions, I'm happy to answer them.
Just bear with me a moment. Just on that last point, Mr. Bajamal,
Yes.
looking at the letter of the 29th of October, it just gives you an IBAN number for the account. Beneficiary is simply Abadge Investment Management Limited, but there's nothing to tell you whether it's a client account or not, is there?
There is we have the transfer document, the transfer form.
You've gone mute. You've gone mute.
Yeah, sorry, because I'm just speaking to my colleague who's assisting me with the document.
Yeah. Is it the remittance document you're looking for? The instructions or banking instructions or what?
If it helps, the letter is at page 33 of the bundle, and the remittance is, I think, at page 34.
Yeah.
Apologies, Your Honor, I'm making some progress.
Yeah. Yes, again, one's got the account number, the IBAN number, but nothing to indicate the name of the account as such, other than the reference to Abadge Investments Management Limited. So whether one can infer from that it's not a client account, I don't know. In the ordinary, oh, hello, that's Mr. Bajamal's disappeared. So he's coming back. You're back again.
For some reason, I dropped out of the call. I don't know why.
Yes. I was just looking at the remission document at page 34, as well as the letter. It gives you the name of the beneficiary and then an IBAN account number, and you're asking me to infer from that it's not a client account.
Correct, because the title would have needed to say the name of the company, then dash client account. That's what the rule says. Well,
that says what the account has to be. When you as a firm of lawyers receive money, you don't always receive checks or electronic instructions that say client account, do you?
But the rule in this instance, perhaps, the regulatory rules for lawyers maybe do not require this, but in this instance, the DFSA rules do require that the title includes this, because the rule states includes the words client account.
Well, I'm quite sure solicitor's client account includes the words client account, but the point I'm making is that when checks or remittances are sent, they don't necessarily include those words, and then have to be paid into client account. I'm talking in the old-fashioned sense of checks. Many years ago, when I used to so act.
I take your point, Your Honor, but that
you're asking for the inference to be drawn. I understand.
Yes.
Yeah.
Yes.
Okay. Okay. Yes.
Yes, I was answering your questions, Your Honor.
You were indeed. You were indeed. The only other thing I just wanted to check with you, because you referred at one stage to documents which were copied to Mr. Naqvi, of those you relied on. Can I just be clear which ones were copied to him and which ones weren't?
Yes. Yes, if you give me a moment, I will find them.
Yes. But some are and some aren't they? And
that's correct. But our submission is that the ones where he was not copied were the ones where he had already orchestrated the answer in the background in the internal emails. So
yes.
he was still aware of them.
I'll need to go through those.
Yes.
But the one you described as the final solution, which is the 30th of August 2016, which is, if my numbering is correct, 2581.
Yes. If you give me one moment, Your Honor, I need to just take out my the hard copy of my bundle.
Yes, it's the last one on the 30th of August 2016, where they're deciding what they're going to do.
Yes.
Quote, this is Lakhani to Wadud, copied to Mr. Naqvi, right?
I'm afraid that I haven't reached to the page yet. I'm just looking at it.
No, I'll wait. I'll wait for you to catch up.
Thank you. Yes, I'm almost there.
Have you got the hard copies to hand in chronological sequence, or what?
Yes, I got them now. So I'm looking now at the page.
Right. So we just to take it in sequence, make sure that I've got this right. 16th July. If you go back to 2577. 16th July. Naqvi himself says to Wadud, copy to Lakhani, a ticking time bomb, we need to allocate it. Karim was one investment, can we deal with it? Then we get Wadud back to Naqvi on the 16th July, same date, page 2576. We can use the vehicle, query Muzoon, that was set aside for Karim. For other investments, we can look at Abraj Holdings position and transfer against cash or synthetically hold the underlying. We'll try and compose a portfolio. And then the next thing we get is August the 2nd, put of 2579, Lakhani to Wadud, but not copied. Oh, a big part, it is copied to Naqvi. Yeah,
it is
copied to Naqvi. Naqvi saying, Naqvi has asked that the portfolio should comprise of investment in Karim, and balance should be shown as cash. And then above that, Wadud to Lakhani, again copied to Naqvi, saying better to do it a different way, synthetically mirror that through documentation that says our share of our limited partner's position has transferred the Karim portfolio of its interest to the Gagawi vehicle at Muzoon. We effectively sell our economic benefit from Karim to the tune of the size of the Gagawi vehicle. So that's, so far, we've got Mr. Naqvi copied in on each one, right?
Correct.
And then if you go to page 2581, the 30th of August, so that's 4 weeks later. Copied again, Naqvi copied in, where Lakhani says to Wadud, here's our final decision. I suggest we allocate 1.5 million to Karim and balance as cash to be invested in future investment opportunities. Please advise. And then what do we get? That is then followed by what? Followed by the 2nd of September email to Mr. Prasad.
Correct.
Saying we've allocated 1.5 million to Karim. This is valued at, and there are a couple of new investment opportunities. So thus far, we are to take it that we had decided, I suggest we allocate back at 30th of August refers to whom?
We in this sense as the group, the Abraj, basically. That's it.
Well, the question I have is, whose decision is this? Is this Mr. Naqvi's decision, or is it Mr. Lakhani and Mr. Wadud, who together have come to that conclusion and are just copying in Mr. Naqvi on it?
Yeah, I think the answer is in the email of the 2nd of August,
right,
2016, where Mr. Rafiq Lakhani is saying, "Dear Mustafa, AMN has asked me that the portfolio should comprise of investments in Karim and balance should be drawn in cash." So that was the last position that was communicated, and in the words of Mr. Lakhani, he has received this instruction from Mr. Naqvi.
Yeah, whether he decides on the 1.5 million as a figure, slightly uncertain, but certainly he's saying Karim and balance in cash, whatever the figure may be, and they figure that they come out with 1.5 million. Okay.
Yeah, and he is copied of that email, so he had an opportunity to
yes, he copied in, certainly, yes.
Yeah.
All right.
Yes.
Very good.
Actually, Your Honor's question reminded me of the synthetically point, which I had forgotten to address, so I would take that as my last submission to you. I would like to clarify that the word synthetic may have, a legitimate meaning in the context of investment banking, where investment managers carry out their regular investment banking activities, such as buying stock or such activities. However, this should not apply. The same logic or the same terminology should not apply in the context of private equity, because private equity is a very different business. It does not involve purchasing shares or daily shares on behalf of investors or anything like that, or bonds or anything like that. It's simply the process of buying existing operating businesses, trying to either turn them around or get their valuation up, and then sell them at a profit, or sell the position at a profit. So by nature, the business of private equity is it goes in a slower pace than trading securities, for example, which have daily high frequencies. So that's the reason I just wanted to point out that whilst it may have legitimate meanings in other contexts, but in this context, it does not seem to have one.
All right, that's very helpful.
Your Honour, my learned friend did not confine himself, unfortunately, to responding to submissions that I made. And there are one or two quick points that I do need to respond to, which are new.
Okay.
Point one, my learned friend took the court for the first time to the letter from Mr. Al-Gagawi of July 2018, which is a letter to be found at page 31. I would simply invite the court to read that letter. It is entirely self-serving, and it is well after both tranches of investment were made. The second point in relation to whether the defendant had pleaded no cause of action in the defence, this is really for your honour's pen, I would ask the court to look at paragraphs 3C, page 1540, paragraph 10, 1542, and paragraphs 13 and 15, 1543. My learned friend, it may have been
Say those again. 3C.
3C 1540,
Yeah.
paragraph 10, 1542, paragraph 13, 1543, and paragraph 15, also page 1543. It may have been a slip of my learned friend's tongue when he referred to Deloitte as being the legal representatives of AIML. They're not the legal representatives, they may be the liquidators. The DFSA in our submission plainly is adversarial one, and it needs to look at the nature of the decision notice and the penalties which are within the DFSA's abilities to impose, and which they did impose. So far as the remittance application form is concerned at page 34, with respect, my learned friend cannot be right, because on that basis, anyone who made a remittance to solicitors without identifying they were making a remittance to the client account would be able to say, well, I've paid it to the wrong account, I'll have it back. Can't possibly be right. And in relation to the final point about who is the we in the relevant email, my learned friend says it's Abraj, not that it is Mr. Naqvi. And of course, Mr. Naqvi is only copied in these emails, and the fact that someone is copied into an email cannot possibly make them a decision maker.
Just one point arising out of what you said about the defence. As I read the defence, you've taken the point expressly that no cause of action lies against the defendant, and that's the essence of what you've been saying. I don't think you plead expressly, do you, that it's the wrong claimant?
No.
I don't see that in any of the 3C, 10, 13 or 15. I don't think say that. Unless I've missed it.
Well, we say that the claim fails to disclose any viable cause of action against the defendant. That could be a portmanteau.
That could mean anything.
It's a composite pleading. I haven't looked specifically for whether we raised the wrong defendant.
No, wrong claimant.
Wrong claimant.
Yeah.
Rather, well, we certainly deny entitlement throughout.
Yeah, the focus is you've got the wrong defendant. You know that no personal liability. Anyway, I could deal with that. All right. I will reserve judgment, but I'll deal with it pretty quickly. You both put in schedules of costs. Is there any particular argument that's going to rise on costs? I mean, this is a win or lose case, or just possibly, I suppose there could be a winning on one tranche, but not on the other. But are there any issues that are going to rise on costs apart from quantum?
I don't expect that, Your Honour.
No, seems to me it's the case that you know, if you win, you get your costs. If you lose, you don't.
It does look that way. It doesn't look as if it's a sort of case where one would want to be keeping it open to make arguments about disparity and matters like that.
Well, what I usually do in such cases is when I write my judgment, I say, without having heard detailed submissions from the parties, the ordinary position would be that costs follow the event. And looking at the figures, then I'll give you a provisional view. And then if anybody wants to take up the point and make further submissions, they can do that probably in writing.
Thank you, Your Honor.
All right,
Yes.
does that cover the ground? And hopefully I'll write the judgment in the course of the next day or so, but by the time it's been through the system, I'm afraid it nearly always takes the better part of a week to get through the DIFC court. And where are we today? Wednesday today. You won't get it before next week, certainly. All right. Thank you both very much for all your help. Very grateful to you. And no doubt see you in due course.
Thank you, Your Honour.
If you'd like to sign out, I'll just have a quick word with the associate, if I may. So if you wouldn't mind leaving, thank you.
Yes, certainly. I'm pressing leave now.